Well, good evening. Good evening to all of you that are here live. For those of you catching this on replay, good morning, good afternoon, good evening, good night, good day. I hope that you guys are doing wonderful. It is Wednesday. It is Wednesday, October 18th. I can't believe I just said that out loud. October 18th. October 18th. Time is a construct. Time is a construct. So, welcome back to Law and Lumber. I am Rob, your humble host, and today we are continuing our recap and discussion of the Maya Kowalski trial. This is the trial of Maya Kowalski, four plaintiffs, actually Jack Kowalski, Beata Kowalski, the estate of Beata Kowalski, Maya Kowalski, and Kyle Kowalski versus Johns Hopkins All Children's Hospital, JHATCH. This is a case that discusses, this is a case whose facts are discussed and documented in the Netflix documentary Take Care of Maya. The case involves a child, Maya Kowalski, 10 years of age at the time she was admitted to Johns Hopkins All Children's Hospital with a prior diagnosis of CRPS, complex regional pain syndrome. The allegations in this case are that the hospital engaged in inappropriate conduct, malpractice, false imprisonment, and battery. Along the course of her admission, she was admitted October 7th of 2016. October 13th of 2016, a shelter order was entered by the court in Sarasota, Florida. That shelter order resulted in Maya Kowalski being sheltered at the hospital, where there are additional allegations that the scope of that order was exceeded by the hospital. And unfortunately, towards the end of the shelter proceedings, a shelter hearing was conducted on January 6th of 2017. Yes, 2017. At that hearing, Maya Kowalski and Beata Kowalski, they were not allowed to have any communication or contact. And then, unfortunately, on January 7th, Beata Kowalski took her own life. Thereafter, Maya was released from the shelter order, and this resulting lawsuit occurred within about a year after that. So the subject matter we're discussing in this is remarkably sensitive, and I understand why people have chosen not to cover this trial. I give that little synopsis at the beginning of the video so people know what they're getting into. And I also have a running banner along the bottom so that people know what they are tuning into when they tune in. There are a lot of people who have a lot of interest in this case, lots of people with a lot of interest in this case, and I do my very best to recap what has transpired in trial. Why are we listening to this guy on the screen? Well, this guy on the screen, me, Rob, hi, nice to meet you. I am a practicing attorney in the state of Virginia, the Commonwealth of Virginia, rather. Practicing attorney, I've been practicing in the area of domestic relations litigation, trial attorney in divorce, custody, visitation, removal proceedings, etc., for over a decade. So this case hits close to home, and it overlaps and intersects with an area of law I'm quite familiar with. So I've been trying to break down what's transpired in court throughout the proceedings to give a better understanding of what's going on. For those of you wondering if the voice that you're hearing is a normal voice, it is not. I am still a little bit under the weather. We're hoping to recuperate. Thank you guys for all of the advice. Due to that advice, I have my trusty bottle of water with both emergency in it, and I have, what was the other advice? Elderberry gummies, zinc, and tons of vitamin C. So I've been doing my best to make sure that the voice is kept up throughout the course of these recaps. This case is important to me. I am a full-time practicing lawyer, but I really do appreciate doing these recaps, and I like being able to break this stuff down. And from what I've seen in the comment section and the people that engage in the chat, it's important to a whole lot of people. So that's what I'm doing here. For those of you guys that are new to the channel, you will notice that there are probably a lot of floating gifted memberships just floating around there. If you see that someone's gifting memberships, you can enable that at the top left corner. I think you can hit the little 3 buttons and you can say enable gifts. What are the memberships? Well, the memberships are kind of the behind the scenes access. Not only am I an attorney that practices law, but I'm also a woodworker. So I build stuff. And I go in the shop and I get to chat with you guys about what I'm doing in the shop. I did want to make a quick comment about the moderators that you will see in the chat here on YouTube that you might engage with in the Discord. there's a whole lot of people. There are a whole lot of people who do not get enough accolades for what they do to support the channel and support the fact that I am going live on a far more frequent basis than I usually am. So thank you to the mods that are here, making sure the chat stays focused, the chat stays engaged, and that the chat is well, there's certain words that YouTube doesn't get like very happy with when you say them in the chat because they're transcribed. So if you can't say a word, if there's a block on a word, I promise you it's not a comment towards you or your commentary. What it is it's basically our moderators trying to make sure that this live stream, this recap stays up for others to watch, because I think the subject matter is remarkably important. So with all of that said, I mentioned the membership because there has been a video I've been trying to put together for quite a while. It's of me making a pencil out of various colored pencils, because I've previewed that in some of the member chats. If you're listening, please tune in to the very end, because we have a new outro, and the outro might just be a little bit of the best type of therapy that I like to encourage, which is go make something, you'll feel better. Just go make something, you'll feel better. I don't care if it's writing, I don't care if it's drawing, I don't care if it's crocheting, stitching, woodworking, metalworking, CNC work. I don't care what it is. If you go make something, I promise you it takes away a lot of the pressure. That's how I relieve the stress of domestic relations litigation, because there's a lot of emotion involved in it, and especially when we're talking about this particular case. So I was wanting to recap yesterday's court proceedings today, and I have that queued up, but I also was able to tune into Recovery Addict's channel this afternoon because I heard wind that there was a lot of discussion about the directed verdicts today. I didn't really anticipate that, so I tuned in to Recovery Addict, who has been a supporter of the channel and who has directed a lot of people here. So Recovery Addict has been doing a great job covering this trial live. So for those of you who want to watch the live trial coverage but don't like the long crime chat, I would strongly recommend that. Recovery Addict is a great channel to watch this trial on, and that chat is awesome. A lot of the people that are here tonight are from that chat. So please, Recovery Addict. You guys also might see a name in the chat, Jules, who's popping in and out, who has been engaging the chat. Jules is in court. No, she is not paid. No, she is not part of the channel, but she is our in-court eyes and ears. And a lot of the information that I'm getting from her is really pretty incredible behind the scenes stuff. So I really do appreciate Jules being here. Let's see. We start today with kind of closing the loop on some of the directed verdict arguments that we talked about yesterday. So without further ado, let's get into it. I actually had a question for you guys. Sorry, scroll side note. Question for you guys. People have commented that sometimes it's difficult to find the different areas within the live stream where I'm talking about subject matter. I have a swoop. For those of you new to the channel who don't know what a swoop is basically a transition. And the swoop that I have is a unicorn swoop. Why is that? Because there's a unicorn that's the channel mascot. This is Ziggy Sawdust. Hi, he's happy to meet you. The backstory on him is too long to explain in this particular live stream, but my question is, shall we implement the swoop when we transition from topic to topic to topic? That's the question. And in answering that question, I'm going to show you the swoop. Here's the swoop. Is that a cat riding a unicorn? Yep, it is. Do I have any shame in that? No. Is it a nice reprieve from the stressful stuff that we're talking about? I think so. So I'm going to put a poll up in the live stream chat so that you guys can vote whether the swoop should become a part of the live stream on these recaps. I usually reserve it for Friday Night Frenzy, which is a show I do on Fridays. Recapping different developments in the law. Should the swoop become part of Maya recaps? Yes, no. Keep it simple. There we go. So that's the question for the chat right now. And because we have swooped, we can now get into the start of the court proceeding that took place today. Now, this was closing the loop on some of the directed verdict arguments that we heard yesterday, and the judge took several of these under advisement. So let's go ahead and make sure. Can we pull this up? Do we remember how to do the things that we should know how to do? I have the court volume gained up 600%. This is a Zoom hearing. It is remarkably quiet. I will therefore reduce my volume on my microphone so that I am not blowing eardrums out of everybody that's listening, so that I can pull up that stream and we can begin our discussion. Let's see. Closed captioning on this one is turned on. Share that. There we go. Because we've already swooped, we're not going to swoop again. Is that poll live? It should be live. Hang on. Let me remove that pin channel, that pin remark. There we go. You guys should be able to see that now. Okay. So we begin today talking about the directed verdicts and the judge, Judge Carroll, whom I have grown to appreciate during this particular trial. Judge Carroll, if you're watching, I apologize for the swoop. Actually, I don't apologize for the swoop. The swoop's fantastic. Judge Carroll, if you are watching, I'm glad, because I am very much in line with a lot of what you said today. So let's get into that. Here. Let's see if this camera will move far enough. I like seeing little movements and stuff because it's funny.
I'll just have to live with me
judges in tech
looking off screen all the time because I can't see it and bring this camera over far enough. So the art of the possible. In any event, going back to the time, certainly there has been some time because of the juror question. So what I'm going to do is I'm going to give each side an additional 4 hours to use as they see fit. That will just be added into the time. Now, I came to that by looking at the amount of time that we've already used with juror questions and kind of anticipating that the jurors are going to continue to have questions. And so that's my approximation of the impact by the juror question. So I will add 4 hours to each side. Now, I'm also going to start trimming our sails a little bit here. By me adding 8 trial hours, we effectively no longer have any wiggle room in our schedule. So there will not, and I have to assume the defense will use all of their time and that the plaintiffs will use all of their time. So unless we've already discussed a day off or there will not be a jury, there will not be any further days off. So that means next week will be 5 days without any days off. The arguments, again, I referenced this yesterday, and I know this is on me because I've allowed it, but I really need the lawyers to confine themselves to have, a single lawyer argue a point. I will certainly listen to it, but I can't have every single lawyer wanting to participate on every single issue.
Thank you, Judge. Thank you, Judge. One horse, one rider. Thank you. One horse, one rider. No more of these endless arguments over evidence with every lawyer in the entire courtroom chiming in. The amount of time that has been consumed over evidence in this case is pretty remarkable. So I am so happy to hear this. Judge, great move. Hold him to it. A lot of egos in that room. Good job. Grab the reins.
Because I need, even though that time isn't attributable to either side, we still have to have time to address exhibits and all the other things. So I really am going to start enforcing that. And so I'm just letting the lawyers know so they can be prepared for that. We've already talked about we're going to start Thursday at 8:15 in the morning. this Friday. We will go until 6 p.m. The jury won't go that far, but we will go here to continue to address any outstanding exhibit issues that arise, because we really have to start finalizing our exhibits. I'm going to start asking next week to start seeing drafts of the table of contents for exhibits for the jury. I don't know if the plaintiffs are going to be doing that or if the defense is going to be doing that Excel spreadsheet, but I really want to start seeing a draft of that by next week. So those are the announcements. Let me now move over to directed verdict motions and my rulings and where I am with each one. I'm going to go through the directed verdict motions in the order that I put them under advisement. The first two motions are for counts 21A and 21B, which is the survivor claim and the wrongful death claim for intentional infliction of emotional distress. Yes, I did receive the plaintiff's memo on this, the defendant's response to that, as well as the plaintiff's reply. I've looked at those memos. And Mr. Altenberg, I have to say that last paragraph of your response memo I thought was very interesting, and your predictions as to appellate relief. But be that as it may, having reviewed everything, I am going to conclude that the plaintiffs did make a prima facie case on both counts 21A and 21B. Therefore, I will deny the motions for directed verdict relating to 21A and 21B. That's counts 21A and 21B.
Okay. Context. Well, there's this reference to a paragraph in a pleading. Why? Well, I'd love to pull that up. Let's go ahead and pull that up and walk through what we're talking about here. So what did Mr. Altenburn file? Mr. Altenburn is one of the attorneys for the defense. He is a retired federal appellate judge, or not federal, Florida appellate judge. 23 years as an appellate, 23 or 27 years as an appellate judge on the second district court of appeals in Florida. So remarkably skilled. There's nothing wrong with the fact that he's in this particular case. Honestly, was a wise move on the part of the defense. What his job is his job in this case is to make sure the law itself is appropriately fashioned in giving the jury instructions, because he's there to essentially argue on the appeal. This case is going to be appealed. I have made that remark before. This case will be appealed. It doesn't matter if the verdict's in favor of the defense or the plaintiff. This case will be appealed. So a lot of this is about preserving the appellate record. The appellate record, when the Court of Appeals gets it, the Court of Appeals gets to make certain determinations, and they're restricted in how they make those determinations. Some determinations are rulings that are given a glance, what's called de novo, which is as if they're looking at it afresh. So they get to consider everything that took place in the trial and make a ruling based on that. Some of them are abuse of discretion, where the judge was granted a certain amount of discretion in making a ruling, say on evidence, whether something should or should not come in. And those are very difficult to overturn. The judge's discretion is given significant leeway in what evidence to allow or disallow. So abuse of discretion standard, very difficult bar to overcome. However, legal standards, what legal standards should be applied, whether this count has merit, whether the count itself is a cognizable or recognizable action under Florida law, whether the elements were properly stated. These are things the Court of Appeals can review de novo, brand new. They get to look at how the judge applied the standard and the standard applied, and they get to say, Judge, I'm sorry, I disagree with how you applied it, and overrule the judge if they feel that's what they want to do. So what are we talking about with counts 21A and 21B? 21A and 21B are, I believe, the suicide counts for Maya Kowalski. So here's the position by the plaintiffs. Plaintiffs maintain that Section 46 supports their position because it allows recovery for a family member who is present at the time when a defendant commits extreme and outrageous conduct on another family member. Okay, so I've made this comment before. There's not a lot of case law for this premise that a family member can recover for intentional infliction of emotional distress for the self-unaliving of another, for someone taking their own life. That's a causal disconnect. I've talked about it at length, and there's not a lot of case law on this point. When you see attorneys citing to the restatement of torts, the restatement of torts is not authoritative at all. It's not binding. It's not controlling. It doesn't mean anything. This means that they have gone through the case law, they've gone through the statutes, and they have no other place to look except for this, which is guidance. And that's where this claim ends up. It's in the realm of, there's not a lot of controlling authority here. It's in the realm of guidance. We have to look to guidance to see if we can make the right call. So with this one is this. So the position of Johns Hopkins, let me see. So the paragraph he's talking about is this last paragraph by Mr. Altenberg. If the court grants the directed verdicts for counts 21A and 21B, the estate will be out of the case. Maya Kowalski's estate is out of the case, and the issue can go directly to the Second District Court of Appeal. Okay. So if Beata's estate is out, it doesn't go to the jury. It instead goes to the Second District Court of Appeals for a determination of whether the estate should have been out in the first place. If the Court of Appeals says it was wrong, it goes back for a trial on this issue. This defendant hopes, so Hopkins hopes, that with proper curative instructions and compliance with the directed verdict by opposing counsel, that the rest of the case can go to the jury and reach a final resolution. That seems kind of ominous. The judgment for the remaining claims may not even require an appeal. I've told you, the suicide claim, that's the money claim. That's the one that's the big one. That's the one where all of the money is tied to. That is the one that's this $220 million. That is where this case is falling. That's the significant one. The judgment for the remaining claims by required appeal. Johns Hopkins All Children's Hospital submits that the Second District will uphold this court's directed verdict of these two claims. Well, that's interesting because honestly, I think that this is kind of, it's suggestive, but it also isn't wrong. If you grant a directed verdict, the court looks at what standard you apply. And if you apply a standard that doesn't require the Second District Court of Appeals to kind of create new law or to dive into the realm of, are we going to expand the scope of these claims? I've made the comment before that appellate courts love to punt issues. They love to punt issues. They don't like deciding hard cases. They don't. They don't like deciding hard cases and making good law. They don't. If you give the Court of Appeals the option to punt, aka if you grant directed verdict for Johns Hopkins, they're going to punt. It's not stuff I like to talk about, but it's stuff that I do talk about. Going on, but if that prediction is wrong, at least the court and these parties will only need to retry these two claims. And it will be, I think that's supposed to be retried. Retry with a clear statement of law as to the elements of the claim in this highly unusual context. The court should grant. What is Mr. Altenburn saying? What's he saying here? What he's saying is that if the court does not grant the directed verdict as to these particular counts, that the rest of the verdict, the rest of the trial, the rest of the outcome from the jury would be so tightly interwoven with this determination that should it be remanded, you have to have a whole new case on all issues, even if this was the only one the Court of Appeals says was wrong. If the jury enters a verdict in favor of Maya, Jack, Kyle, and the estate of Beata on these two counts, and the Court of Appeals says they applied the wrong standard, the Court of Appeals cannot send back just these two counts because these two counts are so significant and impactful that they're interwoven with the outcome in the other counts. So you have to have a whole new trial. This isn't far off the mark as far as legal analysis is concerned. I don't think he's wrong in this prediction, but this is basically him saying to the judge, trial court judge, Judge Carroll, if you're going to make this ruling, just know what that means. Know that if you're wrong, the whole case comes back and we do a new trial. That's what it means. So I don't view it as a threat. It's instructive. It's informative. It's an aggressive position. I think it was a good thing for him to say, look, if you're going to take this position, you're going to take a position because this is what he is previewing to Judge Carroll. This is going to be my appellate position. So that's kind of where that paragraph comes in as far as the the conversation here. Now let's get back to Judge Carroll, because Judge Carroll goes through a really thorough analysis here on a lot of these counts, and it's important to do.
Next, moving on to count 6C, as to Jack Kowalski individually. As a reminder, there's a Jack Kowalski individually, and then also the Maya Kowalski claim. So this next statement is for the Jack Kowalski individually claim. In Florida law, under negligent infliction of emotional distress, there is the physical impact requirement, and there certainly has been a lot of discussion about exceptions to that physical impact requirement. I have previously written, and I didn't write the DIN number, but it's from June 26, 2023, an order granting in part and denying in part summary judgment as to counts 6A and 6C. I did spend some time discussing the propriety of the physical impact requirement. I'm going to quote parts of that order here. Without question, there has been a greater awareness of emotional health and a destigmatization of emotional illness matters over the last couple of decades. Florida's treatment of emotional damages, though, is based on the premise that too many would-be plaintiffs would fake or exaggerate those injuries. Whether that's true or not is besides the point. Florida's common law created this guardrail to help ensure that no false claims are allowed. Perhaps it's time for a higher court to re-examine that common law in this regard. And if there was ever a case to reconsider the physical impact requirement, this would be that case.
This is how trial judges speak to appellate court judges. This is how they speak to appellate court judges.
The physical impact rule is, of course, a judge-made rule, and certainly the legislature could speak on the subject, but in the absence of the legislature speaking on the subject, the judiciary and the higher-up courts would have the authority to reassess the continued vitality of the physical impact rule. I then went on and discussed a couple of cases from the Florida Supreme Court from 2007, where in 2 cases released on the same day, and there's 7 justices from the Florida Supreme Court, that generated 11 separate opinions.
7 justices, 11 separate opinions. How the hell are you supposed to reconcile that? How are you supposed to fashion a clear understanding of the law and the legal standard to apply under that type of scenario? It's a mess. It's a mess.
And trying to reconcile those separate thoughts is pretty challenging. And there was really no clear agreement amongst them other than that the physical impact rule remained. Justice Cantero, who was joined by Justice Wells and Justice Bell, discussed the arbitrary application of the physical impact rule. And that's in the Willis decision, 967 Southern 2nd, 846. And that's Justice Cantero dissenting. And I could not agree more with those 3 justices' views on it. Quote, as it is, our jurisprudence has created much confusion in the lower courts. During the last decade, no less than 9 times district courts have certified questions to us regarding the rule's application or continued vitality. End quote. Justice Cantero and the other 2 dissenters then offered a solution, which would be to allow emotional distress damages where the plaintiff proved by clear and convincing evidence. You know, I continue to believe that there's a fundamental tenet of law, which is the equal application of the law to all. And in the case of the recovery of emotional damages, you know, it seems to me, and I'm just one lowly circuit judge, I think we fall flat here. Why do we have a rule that has so many exceptions that have no principled contours or understandable or articulable connection to each other? Why is it that one plaintiff is able to recover emotional damages where a similarly situated plaintiff cannot, just because the absence of a manifest physical injury from psychological trauma? And how do we continue to declare exceptions? How does that promote stability of the law or predictability of the law? Therefore, someone above my pay grade, I would humbly suggest, needs to reconsider the physical impact requirement. That being said, Florida law requires a physical impact. Here, with respect to Jack Kowalski, there was a number of items that Jack Kowalski contends were evidence of a physical impact. However, those types, or almost every single one of them, the First District Court of Appeal in the Elliott v. Elliott case 58 Southern 3rd 878 said did not qualify as a physical impact. Certainly, there was a discussion about PTSD as well as dysphagia. However, those, in the court's view, align with the number of ailments that the First District in the Elliott case said did not qualify for physical impact. That's a long-winded way of saying that the court is going to grant the motion for directed verdict as to Jack Kowalski individually as it relates to count 6C. Now, with respect to count 6C, as it relates to Maya Kowalski, I'm going to continue to reserve, but I'm telling the lawyers that I am inclined to deny this motion based on physical impacts to Maya Kowalski. What I am allowing the lawyers to do is if they wish to have a further written submission to me as to count 6C, as to Maya Kowalski's claim, please get that written submission to me along with any sort of evidence or provisions of the transcript trial testimony that you support or you contend does not or does support this claim. The lawyers can use the email address that I had authorized for the weekend use. You can use that. So I will give you until noon on Sunday. Moving on to count.
Okay, so let me do this. Let me explain. I'm going to use one of my favorite lines. Let me explain. No, that's too much. Let me sum up. So let me sum up. What is the physical impact rule? The physical impact rule is that in order to recover for intentional infliction of emotional distress, the person that's seeking to recover has to have a physical manifestation of the injury. There has to be a physical impact, something that impacts them physically. Otherwise, the consequence is if you allow it to go beyond that, then people can say, I was emotionally distressed, and the damages become speculative. What Judge Carroll is doing here is the rule itself is still there. It's judge-made rule. It's not statutory in interpretation. The legislature, guys, talk to your legislatures. But what this means is that unless Jack Kowalski suffers some form of physical adverse impact to him as a result of Beata's suicide, then this is not recoverable under intentional infliction of emotional distress. Maya Kowalski, unless she suffers some type of physical impact, physical impact can be my emotional distress was so significant I couldn't work for 2 weeks, and you have the work documents. I had to go and get treatment for this period of time, and you have the treatment documents. You testify that I ran into a parked car because I was distracted because I couldn't stop thinking about this. These are now physical impacts. That's the physical impact. Without that type of testimony or evidence, then this claim, as a matter of law, under that standard, fails. So what Jack Kowalski says, he was distressed, PTSD, etc. These are psychological impacts, seriously mental health issues that are significantly harmful. I mean, they're painful. They're things that change and alter the life of this person going forward. But the law as it stands doesn't allow for these. These aren't cognizable damages. They're not cognizable injuries. And when you don't have that cognizable injury, you can't recover under an intentional infliction of emotional distress. So that's what the judge is doing here. Now, I want to make a comment that I very, very much appreciate the hell out of this judge for doing what he did here. Because what he does is he articulates his disagreement. He articulates the reasons why he disagrees. He lays the record and foundation for the disparate treatment of different claimants and how we have developed as a society in our understanding of mental health conditions. And he lays all of this out, but at the end of the day, he follows the law. He follows the rule that was there. It is not beyond me that judges in other cases I have observed, cases I've participated in, will find ways of restating, characterizing, or articulating evidence that they believe they heard to try and make that evidence fit into this box. That's not what Judge Carroll does. What he says is, I disagree with how the law is interpreted. It's above my pay grade. Someone up there needs to fix it, but he applies it. That is what a judge does. They call balls and strikes based on the rules of the game. They don't get to create the rules. And it sucks for the plaintiffs, but it's the right call under the existing law. Now he's reserving his decision on Maya because Maya does have evidence in the record, I believe, of actual physical impact. So I wanted to give a brief kind of closing the loop on this. I'm not going to go any further into today's proceedings because we get into jury instructions, and the jury instructions are, I mean, that's like brain splitting law. That's going to be a whole nother time. We're going to have to take that up. It's going to be when the jury is instructed. But the other thing I wanted to mention was this was something the directed verdicts were argued 2 days ago. When we talk about the lawyers and the stress that they're under and what they're operating and their conditions are right now, they filed motions on this issue, citing the case law that exists. This stuff isn't on the top of our head. It's not there. We have to research the hell out of it to prepare these things and file them. When I say they're working around the clock, they're working around the clock. These are motions being filed at midnight, 1 a.m., 2 a.m., 3 a.m. They're filing motions and responses, and it's a counsel on both sides. The judge just said, email me by Sunday at noon. Here's my weekend email address. So this is a shout out to the lawyers that are arguing this case. It's a big case, and the lawyers, in my opinion, have been doing a good job. But I wanted to kind of make that comment. The other thing about directed verdicts, people were asking me a question of what they mean. Why are they important? Well, the directed verdicts being granted in one direction or the other also changes how the parties are allowed to argue in their closing arguments. For example, now, based on this ruling, in their closing arguments, the plaintiffs are not going to be allowed to refer to how Jack reacted or responded to Beata's suicide. You cannot argue that. That's impermissible argument because that claim is no longer alive. That claim it's no longer there for the jury to consider. So arguing about how Jack was affected by Beata's act, that's impermissible because that's suggesting that the jury should award the other three that are in the room when there wasn't a legally cognizable claim that Jack had to get there. So this sets the stage for how the closing arguments are allowed to proceed. Again, explanation doesn't mean I agree with it or disagree with it. It's explanation. So that's kind of a summary of where we ended with that was kind of today. And let me go ahead and check this. Let's see. Oh my gosh, the chat is very active here. So we've got 2,000 votes on the swoop being a swoop or not. 88% of you said yes. So there we go. We've got swoops. So without further adu, let's go ahead and do a swoop, then get to some of the chats before we get into today's testimony. I'm also going to make a quick comment here. You guys have been remarkably generous with the super chats, comments, and engagement in the chat. I really wish I could pull up everything. I can't. I have to do this recap. I try to land it within about 2 hours. It's been going a little bit long, but as you can hear, my own health is kind of being affected. So I will, while stuff's going on, I will pull up super chats that don't have a question, things that are just comments. I'll put those up. So, but please keep an eye on the screen. I apologize if that's inconvenient or frustrating to you, but I need to make sure that I'm still capable of doing these recaps because there's a whole lot of trial left to go. With that said, let's go ahead and get into some of the super chat catch up. That's the swoop. So, Ryan YYC, thank you for the gifted memberships. Much appreciated, my friend. AG, exhausted today after a horrid hospital treatment last night. Awful abdominal pain and spontaneous bruising. Ignored by doctors. Scared they dismissed me, and they did. This needs reform. Thanks, Rob. AG, I'm very sorry that you had that happen. I agree that we need to take a strong look at a lot of how these cases are proceeding. Fiona, thank you for the gifted memberships. Much appreciated. Kim Galantini. Where are the nurses' notes? They document Maya 24/7. There's questions about that asked by the jury. Ryan May YYC. Rob needs to come to Alberta and do a joint live stream with Runkle in February. Come on, Rob. Winter in Alberta is not so bad. If you think I have a cold now, winter in Alberta is going to give me a cold. But I still love you. Cosaplex. I hope everyone is having a worthy Wednesday. I hope so as well. Kristen, good question. Has the prosecution, plaintiffs in this case, officially rested? They have. They have officially rested. KC Cat will be listening and lurking, but not in the chat tonight. just sending my daily love and appreciation for all you do. Thank you, Casey Cat. I know this case is important to you, and I'm glad to be covering it. Snazzy, thank you. Rob, we also go over the directed verdicts the judge ruled on today before the jury instructions. Yes, I did. I hope that gave you the recap. I didn't even need to see that. You knew I saw it was important. Thank you. Thank you, Snazzy. Anna will be a part of replay crew today, but dropping by to say hi. Hope everyone takes care during the stream, especially you, Rob. Hope you feel better today. A little bit, but we're gonna try and keep on the healing thing. So let's go ahead and get into some of today's testimony, and I'll pull up some of the other stuff in between. Again, you guys are amazing. Thank you. But I do want to get to the content. That's why a lot of people are here. For those of you that are here, the 4,400 of you that are here right now, thank you. This channel has been around for a little over a year. I love seeing all of you here. I love the chat. Y'all are amazingly encouraging people too. If you don't mind, hit that like button. The content on the Maya has been really important for a lot of people to see. And in order to get YouTube to do the YouTube thing and show it to the people that should be seeing this or this might be helpful to, you got to hit the like button. It's not my rules, it's theirs. If you like the content, please subscribe. We're working our way towards 200,000 subscribers. And I think this trial, you guys have been absolutely generous with your time and effort. So I think that's foreseeable by the end of this trial. All right, let's go ahead and swoop and get into today's testimony. See? The swoop helps things. The swoop is healing. Okay, let's go ahead. Here we go. This is gained up as well. No closed captions on this one. So I will try.
Please be seated, everybody. This is case number 2018 CA 5321. Starting with the plaintiffs, let's take appearances, please.
Greg Anderson, Nick Whitney, Samantha Lawrence on behalf of the plaintiffs.
Really dumb moment, but I wanted to pause here. Why am I pausing here? Because the judge just called out something really cool. And it's, oh no, why is that so zoomed in? This is essentially the court appearance record. You see here who appeared with the plaintiffs. So the plaintiff appeared via attorney Greg Anderson, Nathan Whitney, and Ms. Lawrence. Ms. Lawrence, who just passed the bar. So I loved this moment. It's fantastic. Way to go, Mr. Anderson, for calling that out. Because to be included in that table, and to be included in that announcement, it might not seem like a lot. It's a big deal for the attorney. That's a big deal. Like, that's the first time she's been referred to in front of this court as Miss Lawrence, counsel for the plaintiff. So congratulations, Miss Lawrence. You absolutely deserve it. Awesome moment. And good for you, Mr. Anderson, for calling out. Good for the judge for calling out and highlighting it yesterday. So cool. So cool. So sorry for that little brief thing, but I thought that was, having been a young lawyer myself, one of the most impactful things I ever had was when a judge called me to the bar after I had, or called me to the bench after I had tried a case. It was a case about a year after I'd started practicing. And the judge called me up there. I was scared out of my mind. Judge calls me up there and he says, Mr. Morton, and to my colleague, the counsel that was there, we were both younger attorneys. And he said, I just wanted to let you know, I'm scared, thinking he's going to sanction the hell out of me. I just want to let you know that I have been watching you in this courtroom for a little over a year. This was the judge I tried my first case in front of, a little over a year. And I will say that you have come a remarkable way. You are doing very well. I love having you in front of me. This is a great testament to the bar of how well they're training the attorneys here. And you know, you are welcome in this courtroom anytime. For a young lawyer, a remark like that, it stuck with me for over a decade. Ms. Lawrence, You will remember this day for a decade at least. So wasn't a whole lot with the back and forth on the motion stuff, except for a little bit. We're getting into some of the evidence there.
Howard Hunter, Your Honor, with Pat Crowell's, David Hughes, and Ethan Shapiro on behalf of all Children's Hospital.
And hopefully, Mr. Hughes, you're feeling better today.
I am. Thank you, Your Honor.
Glad to hear
Let me just.
that. Sorry?
I'll be sitting over here, Your Honor.
I know Ms. Kroll's wanted to talk about exhibits.
Yes, please. 'Cause-
You have the floor.
Thank you. Judge, so I'd like, although we haven't moved any in really, but I'd like to talk about the ones that were scheduled for today first, because some of them have to do with our first witness. So if I could direct the court,
Go to 1.5 speed.
direct
It's
the
not
court
that bad.
to defense exhibit 31970001. It's an email from Ms. Laporte to Beata Fall.
And what is the number again, counsel?
Sure, 31970001. I think we just put one. It's on the bottom of the first page.
Oh, thank you, Peter, for sending people over. Glad to see you guys here.
So Judge, just to orient the court,
She's the case manager.
she's the case manager. She is the one that is going to testify. She was on the phone with Beata. That was played in the jury. This is her advising Beata the things that you cannot discuss or should not discuss on the phone call.
Well, you say this is 7 pages. I see the
Oh,
other.
no, I'm sorry. It should just be, no, it just says one. No, 3197, just one page.
And plans.
Well, the main problem, Judge, there's several. The main problem is that this, again, gets into Chapter 39 issues as to management communications between and among the actual, with one of the parties by another party here. I guess they would be classified a party. First, it's hearsay. However, we have been trying, and we tried 3 times to get into evidence. The Beatty email, it's 2123-610. 3 times we tried to get that into evidence, and it was excluded based on the fact that the court did not want to get into any of the Chapter 39 discussions back and forth about the management of Maya in the case, because it prompts us, I guess them in that point of view, to have to come in with countervailing evidence, of which we have plenty, but it's going to quickly devolve into a discussion of what's in the orders, what's not in the orders, and the potency, if you will, of any DCF directives. And pointing out, this isn't even DCF, and this isn't even Suncoast. This is Pathways, which is another contractor, which I believe is either contractor or subcontractor to DCF. So again, we get into a lot of different issues that are inappropriate based on the court's, I think the test set by the court previously in our case.
Well, the case manager was specifically authorized by the court to supervise the calls at this time, right?
Oh, yeah.
So when the supervisor is laying out the ground rules, how is that not appropriate for this time period that we're talking about?
Because the orders in place at this time limit it again to the caseworker and to one other person. The what?
Guardian.
That's right, the GAL on it. And we have issues about Beatty participating in these things. I don't think she's on this particular one. But the point is, we have the orders from this time period, and none of these orders allow the things that they're suggesting here.
Well, but to be clear, you're not suing DCF or the contractor, and so the suggestion that you can hold Johns Hopkins liable for the actions of DCF or its contractors is an inappropriate thought process. So my question to Ms. Corrales is, how do you get around the hearsay issue?
Well, Judge, first it's a business record because it's an email from her work email to the client. Plus, it's not hearsay. It's not the truth of the matter. It's to advise. It's to say that she was advised of these things. It's to show.
This is a warning, like to the people in the chat. The audio during these motions arguments is everywhere. It's loud. It's quiet. It is ungodly loud at some occasions. It's all over the place. I can't control it. They're moving in and out and away from the microphones. So don't go cranking your TV up. I will promise to try and recap as much as I can if it seems a bit quiet. But that's just a warning because I don't want people blowing their eardrums out by cranking this up and then all of a sudden hearing Anderson stapling or shuffling papers.
That she was told these things. And this report's going to come in. She can identify it if it needs identification. And she is advising Ms. Kowalski what you should not do.
We're receiving the evidence exhibit 31970001.
And Your Honor, along those lines, then the plaintiffs will be allowed to cross-examine based on the order in place.
It's Ms. Crowell's turn for
Sorry.
evidence. You all spend a lot of time trying to get evidence in. Defense needs some opportunity to get its evidence in.
Three.
That was where I wanted to make it to. basically, like, you guys remember when the plaintiffs were arguing to get their evidence in, there was a whole lot of time that was spent on that. And this is kind of the judge saying, no, we're now in the defense case. They get to tell me the evidence they want to get in. You can make your objection, but when it comes to argument over what you're allowed to go into on cross, let's reserve that for cross. Like, let's get these documents out of the way so that we can get the jury in here. So that was why I focused on that. Go ahead and bring in our first witness, Ms. Laporte. Let's go ahead and pull up her note.
Thank you very much. Ms. Corrales.
Yeah, no, can I just call Charlotte Laporte?
I've got the swoop. New swoop. Ms. Laporte.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes.
You just walk right over this.
Good morning.
Good morning.
Can you go ahead and state your name for the record?
Charlotte Laporte.
Ms. Laporte, we're going to get into your background, but just so the jury understands where we're going, at one point in time, in November of 2015, were you a case manager involved with the Kowalski family and the DCF matter?
Yes, I was.
Okay, all right. So let's give the jury just a little bit of your background. Can you go through your educational background for us?
Okay, I have my associates in human services, my bachelor's in social work, and a master's in psychology.
Let's talk about your work background. So I understand starting in 2009, you started to work for the Department of Health. If you could explain what you were doing and where you were working.
Okay, so I worked on the University of South Florida campus. That's where they house children's medical services and their medical foster care team. So I was a social worker for medical foster care.
Can you explain to the jury what medical foster care is?
Okay, medical foster care is when a child needs a higher level of medical care. They've come in from egregious abuse or medical neglect, and a lot of times it's the children are on vents. They need higher interventions than a normal foster home would be able to accommodate. So I worked with them to ensure the children were getting what they were needing. The parents were able to be engaged in their medical care to the best of their ability, and attend court hearings, present how the child is doing, how the parents are doing.
Okay.
Thank
So-
you for context.
Was that from 2009 to 2014 that you were involved with working for the Department of Health as a social worker with medical foster care? Is that accurate?
Correct, yes.
Okay, all right. And then where did you go from there?
Then I went to work for Pathways as a case manager.
Can you explain to the jury what Pathways is and the connection with DCF and with Safe Children Coalition?
Okay, so if a child is removed from their parents' care, that's done by the child protection investigator.
Is that CPI? They put a lot of
CPI.
initials. CPI.
Well, I didn't know CPI
that's-
are the acronym for
Okay.
child protection investigator. So after that has the child's been sheltered by the state. So CPI doesn't keep the case forever. They transfer it over to what's called case management, and then we try to start working with the families, the children, to help get them in the services to hopefully rectify the reasons that the child was removed from their care.
All right. And how is Pathways connected to Safe Children Coalition? If the jury sees that, those words.
Right. So at that time it was Pathways, but since then the Safe Children Coalition, we are under the umbrella of the Safe Children's Coalition, their case management unit.
Okay, all right. And how long have you been working for Pathways and in doing this work that you did with the Kowalski family as case manager?
7 years.
So I want to talk about your role with the Kowalskis and that family. By the way, was your role with this family similar to the role you would have with any other family in the same scenario? With somebody
Yes.
that's been sheltered.
Yes.
First of all, did you meet Maya?
I did meet Maya.
And if I suggest to you that the first phone call that, well, sorry about, in addition to meeting Maya, were you involved with supervising Beata Kowalski's phone calls with Maya Kowalski?
Yes, I was.
As of November 15th, 2016, were Beata Kowalski's phone calls required to be supervised?
Yes.
Were you also tasked with reviewing any written communication between Beata Kowalski and Maya.
Yes,
In other words, you had to look at it and approve it before it could be given to Maya. Is that
correct.
okay? All right. In addition, were you also involved with vetting or doing background checks on anyone who wanted to visit Maya Kowalski?
Yes,
I'm going to overrule that objection.
yes, I was involved in vetting.
Compass Point administrator. No, we don't talk about people's looks. I love the blue blazer. It's fantastic. The blue blazer is amazing. Guys, don't criticize. We don't talk about their looks. We talk about what they're saying. Come on. What they're saying.
So, do you recall your first visit with Maya in November of 2016?
My first face-to-face when I went to
Yes.
visit her at the hospital?
Yes, ma'am.
Yes.
At that time, tell me about the interaction with Maya.
Maya was pleasant. She was easy to talk to. I was explaining to her why I was there, that I just needed to go see her and want to see how she was doing. I tried to build rapport, just being more of small talk, and she was showing me her favorite things like Hopkins, whatnot, trying to get insight into what she likes. I kept it as simple as possible because it was the first meeting, and I didn't want to cause any anxiety to her more than I had to.
In your interactions with Maya, I'll strike that. Okay. Striking myself. All right. All right, so let's talk about monitoring the phone calls with Beata Kowalski. Can I ask you to put up, please, 3197-0001, which is in evidence. Do you see on your screen there? Is that an email from you to Beata Kowalski?
Yes.
Okay. And what is the purpose of this email that you sent to Beata Kowalski?
It lays out a parameter to make it a quality phone call, so that it, again, wouldn't cause anxiety to Maya by discussing these types of things. We want it to be a positive interaction. Just what she was
Yeah,
doing,
it works.
going
Go
over
with it.
schoolwork, anything like that. Just to keep her from.
Hello, Beata. I wanted to go over things that should not be discussed during your phone conversation. This will avoid any unnecessary stress to Maya and confirms boundaries. Please only speak in English to Maya. Do not discuss her pain, therapies, or anything medically related. If she attempts to talk about these, please redirect her. Do not discuss any mental health issues. This does not apply to SAD, etc. Please have a positive attitude and redirect if necessary. I want her to be able to enjoy her conversation with you. I will not interrupt if it's not necessary. If I do interject, please be understanding and adjust to whatever suggestions I make. If the conversation becomes inappropriate, I will have to end it. I want to avoid any negative, hurtful situations. Thank you in advance for your understanding of these matters. Charlotte Laporte, Child Welfare Case Manager, Pathways. So this email is in line with what I would expect to see. This email might sound harsh. This is a proper email. There's nothing wrong with the email or what she says.
Going into anything that related to the case or the particulars of the case. It was supposed to be a quality call.
Right. And at this time, these were supervised calls, correct?
Yes.
All right. So is the reason to please only speak English to Maya to allow that supervision to occur?
Correct.
Overruled.
I didn't hear your answer.
Correct.
Then there were some other guidelines that you put on there. Excuse me. Do not discuss pain, therapies, or anything medically related. That was also relayed to Beata Kowalski, correct?
Yes.
Overruled.
You also advised her not to discuss mental health issues as you laid out in the email, correct?
Correct.
All right. Now, I don't see in here any direction to not discuss the actual DCF case. Well, I'll strike that. We'll talk about that in a minute. All right. So as a result of your role as case manager on behalf of DCF, did you then monitor a call with Beata Kowalski,
Yes, I did.
the first one? Okay. And have you had an opportunity to listen to a recording of that call?
Objection. Why do you?
Anderson is, so if you hear a voice very, very, very close to a microphone, that's Anderson. That's Anderson. He is ready to pounce on objections with a lot of this stuff. Both witnesses today. He's really, really, really trying to make it difficult for the defense to get their information in. People are making a lot of comments about the Polish, why she had to speak in English. The reason why, and this is not dismissive of heritage or anything like that. This is because if you're monitoring conversations If they have to be supervised, then the supervisor has to understand what's being discussed. If you just switch into Polish and start talking about treatment, care, medicine, etc., and just violate the court's order, then that can't be monitored. That's why you have to speak in English in these calls. You have to. So it's a really, really important point. And when it was kind of disingenuous for the plaintiffs to say that she couldn't speak in Polish and it was important to her, because this part, now the order's in place saying it has to be, it's supervised. So there's a lot of leading on direct. There was a lot of leading when Anderson went too. So they're leading all over the place.
I would like for you to listen to a recording that the jury's heard twice already. If you could play 2608A.
I'm sorry. This was a comment I have to make here. Get a Polish interpreter, make it their problem. You can't, because interpreters are there to interpret. If the words are already out, the supervisor can't redirect. If the words are spoken in Polish and the supervisor has to wait for a second or two for the words to be interpreted, there's a lot of discussion that can happen. So I'm sorry, this might be frustrating to people. This is the rule. These are the rules. Hard and fast rules. This is how supervision takes place. Whether it's a custody visitation, anything. Supervision takes place in this method, in this format. It does.
Okay, I'm recording this phone call so everybody knows. Okay, hi mommy. Hi honey, how are you, sweetie pie?
Can we go to real time so you can hear the voice?
I'm great, I miss you. I miss you so much too. I miss you so much every day. Every single day. You know how happy it makes me feel to hear your voice. Same here. I miss you so much, and I am so happy that I'm finally able to hear your voice too. Yeah. Oh, yes. What did you say, sweetie? I hope I can see you soon. I would love to see you soon. I would love to see you soon. We just have to wait for the judge to make the decision, okay? As soon as he makes the decision, then I'll be able to see you. Okay? Yeah.
We're not about the case, okay? Maya, honey, we're gonna talk about what you've been doing, if you need any Hopkins or things like that, if you had nice visits with your daddy, but we can't discuss the case, okay, honey?
Ms. Laporte, whose voice is it on the recording redirecting Maya Kowalski?
That's my voice.
That's your voice?
Yes, you can hear my voice. So yes, that's my
How
voice.
confident are you that that's your voice?
I'm very confident.
Let's play 2608B, please.
How you doing? How is PT and OT going for you?
Not good. Okay, Bianca, we can't discuss any of those type of matters, okay?
Okay.
On exhibit.
All right, I'm gonna speed it back up because I'm conflicted. Me personally, I think it's Laporte. That's me. I think it's Laporte. So I think it's Laporte. Kurt, chill out. Chill out. We're not causing problems here. Chill. We're good. Everyone's good. Plus, let me shout out your video. Don't be multiple language stuff. I want to shout your video out later. Okay. Anyways, in my mind, I don't know. In my mind, that sounds closer to Laporte. But here's the thing. The jury asks if they're going to get some type of proof as to who was on the call, some type of logs or register, anything like that. They're going to get this information. That's what they're asking for. And the judge says, no, this is a matter of fact. You have to determine who you believe more. Do you believe Maya and Jack and their statements that this was Miss Beatty, or do you believe Ms. Laporte, who says this was my statement? That's what it is. It's you have to weigh this. You have to weigh this. People are saying do a poll. We can do a poll. I can do a poll. Let's do that. That's a good one. We can ask that question and see what you guys are thinking. Like I said, for me, that sounded like Ms. Laporte. The high tone, that was, to me, it sounded like Ms. Laporte. Was the voice interrupting the call? B-E-D-Y. Is it B-E-D-Y? It is B-E-D-Y. Kathy, I think it's Kathy Beatty, B-E-D-Y. Yeah. Or Laporte. I'm going to add the option. I can't tell. So those are up. And then you have Kathy's admission, which I don't know if the admission was. I'm really torn on this. I don't know. I don't know that it matters, though. Well, not to the jury, because the jury right now, the jury doesn't see a disconnect between Laporte and Beatty. I don't think they do. Now, legally, they should. Laporte can interrupt, Beatty can't. But I don't know that they do. Because a lot of people are talking about how it doesn't matter if it was Laporte that interrupted, it was still wrong to interrupt. Well, Laporte is authorized by court order to do that. Beatty is not. So, I don't know.
2608B, which is a continuation of that call, Ms. Laporte. Is that also your voice? Again, redirecting Ms. Kowalski.
Yeah.
Let me ask you this. Why were you redirecting her at that point?
Because it was going towards her medical care. I redirected her about court because we had already previously spoke about that. It wasn't in the email, but we had spoke about it. So the redirections, I don't like having to redirect. It's better if the parent just stays on task, because again, that causes anxiety.
I'm sorry, Karen.
It's better if the parent just stays on task and makes it light for the child, because it causes anxiety. But yes, that was my voice.
Okay. Let's hear 2608C, please.
What do you think is help with?
I can't.
What happens with the pen?
I just can't lift them up.
You can't pull up the pants anymore?
No.
When did that start, Maya?
Oh, I don't know. Maybe a little ago. I don't know. Yeah. I don't remember when I started.
Me. Are Spanish speakers forced to speak only English? Doubt it. Why the separate rules are Polish? False. Spanish speakers are forced to speak English in supervised calls, or the department has staff that speak Spanish. That's the difference. This is about resources. This is not about fundamental fairness. This is about resources and the ability to supervise. The ability to supervise takes precedence over your ability to communicate. That's what the court has placed. You want to communicate, that communicates subject to supervision. Period.
Okay.
TBH.
What's
Oh,
TBH?
yep. I don't even know what that line of conversation. Thank you.
Okay.
That's my voice.
Okay. How confident are you that that's your voice?
That's my voice. I'm very sure.
Well, let's talk about how you had to arrange.
Very sure. Yes.
Let's talk about how you had to arrange the phone calls. You were not present in the hospital when that call was being made and you were supervising it. Is that correct?
Correct.
So can you just explain to the jury, first of all, what schedules had to be accommodated, how you had to arrange the calls with Maya Kowalski?
Okay. So to be able to arrange the calls, I had my schedule, because I had other cases at the time. I had to be out in court and field and all kinds of different things. So my schedule, be out of schedule because she was working. The hospital, because they have to be able to accommodate someone to be in there to help get her on the phone. And then there's also Maya's schedule because she was in therapies and had other things. So it kind of was like a chain that had to all come together.
With respect to this phone call on November 15th, that the jury just heard snippets of, were you connecting with Kathy Beatty for that call to make sure that it happened?
Yes, I recall that I had to coordinate with the hospital, and I did a lot of coordination with Kathy because she would then have an aide available or somebody available to be able to accommodate the phone call.
And was it typical that in your role with DCF that you would coordinate with the social workers at the hospital?
Yes.
All right, I want to go to the end of her direct because she runs into some hiccups. And it was creating a challenge for her getting questions.
But to be clear, the pathway of that communication was it wouldn't go directly to the hospital. It would have to go to you first, and then you would forward it to the hospital.
Yes.
Correct? Do you recall making arrangements for Beata Kowalski to have a phone call with her daughter on her birthday, on Maya's birthday?
Yes, I do.
Okay. And was that on a Saturday?
Yes.
And did you coordinate that with Kathy Beatty, that even though it was on a Saturday, you would volunteer to supervise the call, and Kathy Beatty arranged to make sure that that call could happen?
Yes.
May I approach her?
Yes.
So she's trying to navigate a lot of really complicated legal arguments as to what she can argue or not. Let's go to cross.
Now, Ms. Laporte, you were aware that Beata Kowalski did not want Kathy Beatty on these calls, were you not?
I don't recall specifically that she did not want Kathy on the calls. She would question me if Kathy was in the room and why the phone was on speaker. But again, there was two approved supervisors, myself and the guardian ad litem, and then we have to have someone from the hospital. So if Kathy Beatty was in the room, it's because she was helping to facilitate the phone call.
Oh, that's not my question. My question was, were you aware that Beata Kowalski did not want Kathy Beatty on these calls?
I can recall a specific email where she had asked why Kathy had to be in there and that she did not want her on speaker.
It was a little bit more than that. She said,
Objection, Your Honor.
If you need to refresh your recollection, you can do that.
I shall.
Don't read it to the jury.
I won't. Yes, Your Honor. So let me show you trial exhibit, although I don't think this one's in evidence, 2123-670. May I approach you?
That was such a dumb non-answer. That was such a dumb non-answer. Why avoid it? Answer it. Yes, I was aware she didn't want Kathy Beatty in there. She wasn't in control. I was supervising the calls. I had to have someone in there. Answer the question. Like, what? Answer the question. You made it look worse by not answering the question. Answer the question directly. If she had answered that question directly and owned it and said, yes, I knew that she didn't want Kathy on the calls. That wasn't her call to make. Yeah, you might piss someone off in the jury, but you're not looking like you're dodging the question. It made it worse for everybody. Erica, remarkably generous of you. Thank you. I swore Beatty admitted it was her, but I went back to her depot and couldn't find when she did. Why do so many people remember her admitting it, including myself? Because it's now ingrained. This is a big part of trials. It's a big part of trials. Now it's a judgment call of who you believe. Thank you, Erica. Very generous of you, very kind of you, and very great of you to impact the chat like that. That's awesome. Thank you for going back and taking a look. I hadn't gone back, but I was curious about it. Rebecca. Oh no, Rebecca, Cowboys #1. As a Washington fan, I one of my best friends is a Cowboys fan, and I rib him all day. But that's not what this is about. Rob, loyal lawyer, Peter. However, he can't speak to a lot of this. I watch your recaps. Thank you for that. I have questions that Peter can't answer. Why is it that mom unaliving herself is the hospital's problem? That is a her thing. Yes, I'm an RN. I tried to explain that earlier. I'll get there. Excuse me. It's a really good question. The hospital, well, I'm going to say this. Rebecca, stick around. I will pull this back up later and I'll give you a more comprehensive answer when we're done with these questions or we're done with this testimony. Promise you. I'm not going to let squirrels take over entirely. Thank you to the chat saying Bush. It was a cough. Thank you. Okay, approach. Approach.
That's the exact language used. Would refresh your recollection for me to show you a series of emails where Maya Kowalski addressed this.
Okay, you're going to read it to me?
Yeah.
Okay.
No, I can't read it to you.
I'm sure you.
Oh, that's fine. I'm gonna need to put on my glasses though.
Okay. Again, this is to you, November 16, 2016, finance approach and metrics. And you're about that. I just kind of put a couple of.
And just review it to yourself.
Mhm.
Sure, you can come up. And when you're finished reviewing it, let us know.
I see. Okay, yes.
And one for you from December 6th, but for the record, 3217-0673, and I believe this is an evidence of.
Okay,
Does that refresh your recollection about Maya Kowalski's wishes?
yes.
I do,
You did not
Della.
want Kathy Beatty on those calls, did you?
Well, my interpretation of this is because I cannot,
I don't want you reading the email. Does it refresh your recollection as?
It
to-
does, yes.
Then just tell him your recollection.
okay, so my recollection is that she did not want her to be part of the conversation. So she was not part of the conversation. If she started to facilitate the call because she was the person available to do that, she was not included in the call. She never in any way inserted herself into the phone calls.
Are you trying to tell the jury that you reviewed every single phone call between Maya Kowalski and Maya?
I can only speak to the ones that I was involved in.
So you don't know what went on in the other calls, do you?
No, I can only speak to the phone calls I was involved with.
And in this instance, you would call her and then you would merge the calls. Is that right?
Yes,
And then after that, you would, and in this way, then that was your connection, right?
correct.
And in some occasions, Beata would complain because there would be background noise. Recall that?
I don't recall that.
Okay, all right. So afterwards, I guess to make sure that you knew what dates you were on the calls, then you had handwritten notes, did you not? You would write it out.
Oh yes, I did write out my handwritten notes.
And then later you would, I guess, transpose the handwritten notes to writing, right? You would type it up, right?
Yes,
And you produced the typed versions here, have you not?
they're part of our system. So
Right.
they're in the system.
Where are the handwritten notes?
The handwritten notes are in my office.
All right. Well, I thought you had said before that you destroyed the handwritten notes,
I never said I destroyed the handwritten notes.
but you do not have them here today.
No.
All right. So now the reason that you were,
I called the defense out for this. I'm going to call Anderson out for it too. The implication, that's improper, bud. Anderson, come on, man. I called the defense out for doing it too. You want her to bring all her handwritten notes? Did you ask her to? Is it a subpoena to seek them? Did you ask her to bring them? No. Are you implying to the jury that she somehow should have? Yeah. I mean, come on. Both of you. Defense and plaintiffs, get your shit together. Just
monitoring these was to keep Maya safe. Is that right? To help promote her health and her safety, so forth.
Monitoring the calls?
Yeah.
Just so that I could facilitate a phone call between a mother and a child was really the main reason for the calls.
I understand. But the idea was to keep Maya safe or free of harm from issues or things that might be communicated to her. Is that right?
Yeah, ready?
there's a lot of back and forth because this is a freaking tightrope. This is the tightrope. You got to walk the tightrope. Like you, any step in one direction or the other with evidence gets into the DCF investigation, and that's Chapter 39 immunity. So this is these two attorneys trying to craft questions. They're so careful.
Are you aware that the testimony about that one call there there's been other testimony here today that recognized that voice as Kathy Beatty's?
I was made aware that someone had said it wasn't my voice. I was told that two people said that it was not my voice,
All
but
right.
I don't know who they were associating that voice
Okay,
with.
so they didn't tell you it was Maya Kowalski?
Maya Kowalski.
Maya Kowalski identified the voice as Kathy Beatty's.
Okay, that it was absolutely my voice. I think anybody that has heard my voice in here today and on the recording could tell that that was my voice.
I was simply asking you if you knew that Maya Kowalski identified.
I did not know that. No,
And who is Jessica Blackrick?
she's the guardian ad litem manager. She was one of the people approved to supervise the call.
And that she identified on those calls, some of those calls in any event, that they were Kathy Beatty. You're aware of
That's incorrect. It was me.
that? Okay, so in this role, again, I can't get in. I got to approach to ask before this question. Sorry, guys.
Rebecca in the chat, I didn't shut you down on a question. I didn't shut you down on a question. I said I'm going to get to the question. It's outside of the context here. I promise you I will answer the question. I promise you. And I need to do it in a setting where it makes sense that I'm answering that question.
Based on sort of no further questions.
I'm sorry, was there another question?
Yeah.
Ms. Crowell?
After the November 15th phone call that the jury heard snippets of, did you have communication with Beata Kowalski addressing, again, why you had to redirect her?
Objection to say.
I'm just asking if she, okay. Did you, sustain?
Sustained.
Did you have further communication? Just did you have further communication with Mrs. Kowalski, with Beata Kowalski?
Yes, I did.
1 minute.
Yeah, members of the, or on that one question, do you have any follow-up?
No, Your Honor, not on that one.
Really?
Really?
Members of the jury?
Really?
any questions?
Yes.
Okay, so we go to jury questions. Let me make sure I got that.
There's quite a few questions from the jury. I'll tell the jury, I think I can ask most of them. There's a few that I cannot. If you know, what is the average time to process, get court approval, and communicate across all channels?
Do I know the average time?
Yes. If you know.
There was no average time. It depends because there was.
I'm sorry, Your Honor. I can't hear you.
Yeah.
Sorry. There was no average time because everything was its own case scenario, and we started whatever we were informed to do. We did it as soon as possible and coordinated the best we could to accommodate everyone and what was being asked of us.
Exhibit 2608, the phone call, doesn't have a time. Please describe the time email was sent in relation to the time the phone call was made.
The email for
I'm assuming it means the email that was discussed in relationship to that phone call earlier in your testimony.
right there had been I had sent an email. It wasn't sent timely. I had been getting instructions as to additional
3 minutes
guidelines
before
to
the
be able
call.
to facilitate the phone call, but I had already previously spoke to Beata, and that's how she knew the understanding. Don't talk about the case. That was to reiterate. I had also sent an email. I can't remember when. I don't recall when, but there was phone calls and emails, and during that call, again, she did pretty well, and I just had to redirect her a couple times as to what the conversation was.
And the next question from the jury is, when you forwarded correspondence to the hospital from Beata Kowalski to Maya Kowalski, who did you forward it to at the hospital?
With that, I would forward it to Kathy. That was who I would forward it to. She was a social worker, so that would be my point of contact at the hospital.
Why did Jessica, the guardian ad litem, only supervise 2 or 3 calls?
I can't speak for Jessica why she only did. I don't know that I don't know what her schedule was, why she couldn't accommodate them. I accommodated them as I could. And I can't answer for Jessica why she couldn't.
And I can't ask the balance of it, but I just will remind the jury that I will give you the outline of the court orders with respect to this issue. Okay. After you sent the written letters from Beata Kowalski to the hospital for Maya Kowalski, did you follow up to see if Maya Kowalski ever received those letters?
Yes, I can't say that I followed up to see if she received all of the letters, but usually if I was having a conversation with Maya, I would be able to confirm that way. I would confirm with Kathy that Kathy received the letter. And to my understanding, Maya did get the letters that I forwarded.
Do you know if Kathy Beatty also stayed in the room and listened in on the conversations between Maya Kowalski and her mother? Or was there anyone else in the room listening to the phone calls?
Okay, so I can't speak directly to that. I will say that during the phone calls, they did help facilitate to get the calls to get Maya.
I don't like this. I don't like this. Like the excuse me. Excuse me. I'm sorry, I've been good about muting. I don't like this. One of the comments that I saw in the chat, which is actually really accurate, both with this witness and then kind of with the next one. These are jury questions. These are jury questions, questions from the jury. Can you just take your head and turn it that way? Like, they're the ones asking you. They're the ones asking you. Please. And it's not that what she's saying is wrong. It just gives the appearance of discomfort. This is a courtroom. This is theater. And I don't mean to say it's theater. It's truth and it's fact and false. It's truth and lies. But it's also
On the phone. I wasn't able to see who was in the room. My concern was that I merged the phone call. Maya was able to have her phone call and she was able to speak with her mother. I wasn't questioning the hospital as to who was in the room. I know Kathy had facilitated getting her on the phone. I don't know how often she actually stayed in there, but she was never part of the phone call. She never intervened, never interjected in the phone calls.
is the jury present for
Upon
this, by the
first
way?
meeting face-to-face
Or
or
is this
any prior
outside?
or future phone conversations, was it made clear to Maya Kowalski why you were there to talk with her, meaning Maya, that you were assigned to monitor her conversations, her well-being, who you work for, or that she, being Maya, was in the custody of the state of Florida?
Okay, so
Hang on.
from my onset of beginning to work with Maya, that's why I said it began at my first visit with her that I was trying to build rapport. So at that time, there was an understanding I was going to facilitate the visits, that she was going to have a visit with her mother. And that was also, I can't say for sure, but I would imagine because she was aware of the phone call that the hospital would have discussed with her too, that she was going to be having phone calls with her mother.
Next question. Are you telling this jury that only you monitored Maya's phone calls?
No, I'm not. I'm saying I can only speak to the phone calls that I monitored. I was aware that the guardian ad litem did.
That's a bad question. That's a bad question. Like for the defense. That's a bad question. Let me tell you why. Are you telling this jury that? When have you heard that question being asked? Cross-examination. It's being asked in cross-examination. I made this observation yesterday when I was doing kind of a like catch up on this. This is a cross-examination question from the jury. Are you telling this jury? This is the jury. Like, are you telling this jury? So now the jury is speaking in third person. So the jury is speaking in third person, apparently. Are you telling this jury? Are you telling me and my colleagues? Are you telling me and my colleagues that? So this was and the jury does this with both witnesses, both live witnesses. So, wow, I heard that and I was going, oh my God. Oh, wow. Wow. Okay. All right. That caught me off guard. I did not expect to hear that. I didn't expect to hear the tone of that.
Facilitate phone calls. I wasn't sure how many, but I can only speak to the ones that I supervised.
Are you able to attest that all of your calls to and between Maya Kowalski and yourself, end quote, facilitated, end quote, by Kathy Beatty, were not, quote, listened into, end quote, by Kathy Beatty with or without your
No.
consent?
She can't.
I can't attest that Kathy didn't listen to the phone calls. She was at the hospital. I can only say that there was no interjection by Kathy during the phone calls. I can't speak to exactly what Kathy heard. There was also aides that facilitated phone calls. So it wasn't just Kathy. Kathy would coordinate to be able to have either an aide or someone else sit in to get her be able to be on the phone.
As a person in charge, did you explain to Maya Kowalski when she was telling her mother she was having trouble with her pants, you stopped the conversation? Who was Maya supposed to tell, and did she get help?
I didn't stop the conversation then. That wasn't, I only stopped the conversation when it started to revolve around her, the case, her therapies. And then there was a strange statement that she had made at the end. And I redirected that because I didn't understand what she was saying. And her mother did.
It's TBH. She says TBH. I heard it the first time. How many times have you heard this? She says TBH, to be honest.
Didn't either. So I wanted them to just keep trying to keep it smooth. About the part about her pants, I did not interject at that time that I recall, because that wasn't inappropriate. It was just her saying that she was having issues with her pants.
And there was a request from one of the jurors if there was a way to tell who the voice is on the phone calls. I will tell the jury this. The jury is to determine facts. And that would include if there is a conflict in the evidence, it's up to the jury to determine the facts. Okay, with that, Ms. Corrales, do you have any further questions?
I do not fault her for cutting off the TBH. I don't fault her for cutting that off. I don't fault anyone for cutting that off. If you hear that, look, here's the thing. This particular case is probably less severe than a lot of cases that Ms. Laporte has had to. I am sorry, Ms. Laporte. I didn't mean to do you like that. There you go. That was a bad pause. This case is less severe than I think 90% of the cases that she has to supervise. So in a lot of cases that we have supervised contact and visitation, the supervisor is trained to cut off immediately and redirect at even the slightest indication. That's their training. That's not the hospital. That's the training they get. Not the hospital. Two parties. Remember this. Two people. Laporte, DCF. Hospital, BD. Okay? So the supervisor is trained to cut that off. Hearing TBH, if you're not paying full attention, you hear that, I don't blame her for cutting it off. I don't. But you've heard it like 5 times, man. Like, you know it's TBH.
Questions?
I do.
Let me ask you this. Do you specifically recall the dates of when there was some concern by Maya Kowalski that Maya wasn't getting her pictures, or would it be helpful to review something to refresh your memory?
It would be helpful to review something.
Good redirect.
Okay. Can I approach, Your Honor?
Date,
You may.
Yeah. You want me to establish the date?
that would be good.
Okay, all right. So let me ask you to review this document, starting with the second page. Counsel wants me to advise of the date. Is that right, Your Honor?
You showed him the document, right?
Yes.
So this is refreshing recollection, so just have her review it herself.
Okay, all right.
Yeah, no.
So
Good
Secretary
judge.
Niekus,
Good judge.
you can review
Okay.
the document.
We don't get a whole lot more from this witness. We need to go to the next one. Argument, more questions. I know that people want to hear more of it, but I need to make sure I'm alive by tomorrow to continue doing this. So, oh, wait, we need to preview why this next witness is going to be
Members of the jury, I think we need investigation and
going to be
presence. We can be
complicated.
seated.
Judge, can you-
Crawford? No.
Okay, so may this witness be excused?
We want to keep her under subpoena, Judge, but she was excused this time.
Okay, so you're free to go today, but at some point you might be called back, okay? Have a good day.
Did I leave a document? Yeah, I'll take that.
Try to keep it to 10 minutes. Just reminder that at no later than
Yeah,
11:55, I'm going to have to
Before they come back.
take a break because I've got that meeting.
Spinny wheel.
And defense, who do we have next?
Defense would like to call Ms. Tori Niehus, please.
Okay, are we ready for the,
I wish to bring to the court's attention, I mean, Ms. Niehus has been deposed twice, and she had a habit
Swoop. Motions and argument.
But just throwing things out, like, quote, the mom was putting in her a coma every week.
Oh, hold on. The witness is in the room at the moment.
Oh, can we? This is
Ma'am, if you could step outside.
Oh, shit.
very nice.
Oh, crap. They were about to have a full-on argument over what she was testifying to, and she was sitting in the room. Oh,
So what's
damn.
the issue?
The issue is, I'm wondering if there should be a proffer, number one. Number two, maybe we don't need a proffer as long as we have some assurances that there's some control over this witness and the witness will not be randomly throwing things out that she has absolutely no knowledge of.
Your Honor, I discussed this with the witness. There's not going to be any randomness. She did 4 supervised visits. She's going to talk about those visits. If Mr. Anderson would like a proffer. we're more
Oh,
than willing.
Hughes is doing direct.
You know, I don't think I need to, as long as she's not going to do what she's done in the depots.
I'd also like to draw attention to the court, since we're on this topic, that Mr. Anderson did quite brutally cross-examine Mrs. Niehus about her special needs child, and she's very anxious that that's going to come up today. It has absolutely zero relevance to anything to do with this case. But since we're talking about threshold matters, I'd like an assurance from Mr. Anderson that we're not going to get into a special needs child.
All right. In this instance, the witness attacked Maya Kowalski and the Kowalskis for having a, what was it? Yeah, it was a GoFundMe account. It turned out that this witness also had a GoFundMe account for the same reason. She had a child with a disability, illness. The Kowalskis did. It was a fair comparison, but it has no place in this courtroom for this, unless the witness is going to again comment on the Kowalskis GoFundMe.
Are we both sides done kind of throwing elbows at each other? Are we ready to bring her in and
Oh, Judge. Oh, God, that's so great. Are you guys ready to be adults? Are we ready to actually be adults? Or are we going to be, children arguing? Children. We would like to continue with the trial. Are we going to just keep on this like measuring competition, or are we going to allow the trial to proceed? Oh, God bless.
conduct ourselves like we should in front of a jury?
I think so.
Mr. Hughes?
Ready to go?
Okay, let's bring in the jury.
While she's being brought in, the results of the poll with 2,357 votes. So 2,357 of you. 43% said it was Kathy Beatty. 34% said I can't tell. 21% said Laporte. So that's an interesting split. The jury gets to make the call. Very interesting. Very interesting. I figured that split would be right about there. Very curious. And I'm glad I put that poll up because I wanted to see how people saw that. Guys, there's 5,400 of you guys here today. I am under the weather. I am sorry. I am coughing. If you wouldn't mind hitting the like button, consider subscribing. Much appreciated. Oh, come on, Judge.
Mr. Hughes, if you can call your
The
next
defense will be calling this Tori Niekus.
Happy birthday, Cloaked Librarian.
Stand here, face the
Thank you, Recovery Addict. You're awesome. Thank you.
I do.
Good morning, ma'am. How are you doing?
I'm good.
Can you please state your name?
Tori Niehus.
And you live here in Florida, is that correct?
I do.
You relocated from somewhere else, though, did you not?
Wisconsin.
How long did you live in Wisconsin?
My whole life up until 2011.
Can you please tell the jury about your educational background, where you went to college, any degrees and licenses you've obtained over the years?
I went to college to earn an associate's degree in police science, where I graduated with President's Honors. During the time I was in school, I was hired at the police department and worked
in dispatch and became a certified emergency medical dispatcher. I was at the police department 9 years. Within that time, I also became a certified firefighter and a certified EMTI. I earned a CNA certificate when I started this whole process. Clearly, I wasn't so sure on which route I was going to take. I just did that for about 23 years.
And what is a CNA?
Certified nursing assistant.
And can you please explain to the jury what an EMTI is?
EMTI is very similar to a paramedic level here in Florida. However, they don't have the I here, but in Wisconsin, we became a I squad where we're allowed to, as EMTs, start IVs, give certain cardiac medications, certain diabetic medications. We were trained to use the life pack defibrillator. It just allowed our squad to give a higher level of care than just basic EMT.
And where are you currently employed?
I currently work at the United States Postal Service.
It's fair to say you've worn a lot of hats over the years.
Fair to say.
One of the jobs that you used to have was with the Safe Children's Coalition. Is that correct?
Correct.
What is the Safe Children's Coalition?
The Safe Children Coalition is a nonprofit organization that works alongside child protection services, the foster care program. We do a lot of education, safety, a lot of resources.
And how long approximately did you work with the Safe Children's Coalition?
I believe it was 2016 to 2020.
And what was your title with the Safe Children's Coalition?
I was a family support intervention specialist.
And what does a family support intervention specialist do, generally speaking?
Well, a little bit of everything, actually. I did supervised visits. I would transport children to appointments. Sometimes I had to take children to the hospital to be evaluated by a doctor, take them to school or pick them up from school. I would help families with resources. Sometimes kids aren't always removed from their home. They just need resources within the home. So I was able to provide resources for in the home, and then also assist with child protection when there would be a removal.
And when you were working for the Safe Children Coalition, were there times you would work under a Safe Children Coalition manager?
Always.
And what is a Safe Children Coalition manager? What's their role?
They work very closely with child protection and determine whether certain maltreatments require removal or not removal. And as a team, we work side by side with one another, determine the needs of the family. Again, whether it's opening up a case for a removal or a non-removal, and we put services in place.
Okay. Did you work with a Safe Children Coalition manager back in October of 2016 and November of 2016 with respect to Maya Kowalski?
Do you mean my supervisor or a case manager?
The Safe Children's case manager.
The case, I did work with the case manager, yes.
And what was her name?
Charlotte Laporte.
And did you also have a supervisor as well?
Yeah, I had several supervisors, but my main supervisor was Angela Murray.
And if I understand correctly, you were present for 4 visits at Johns Hopkins All Children's Hospital.
This woman is depot scarred. So she is depot scarred. I have made this comment before. Deposition scarring. Basically, when a deposition is so brutal that you get on the stand and you are so anxious that your testimony comes across convoluted, nervous, apprehensive, because the deposition was savage. Now, the deposition was savage and the cross was savage for a lot of reasons, but this was depot scarring for sure. But this witness also doesn't do a whole lot to help herself. Now, I want to be clear. This witness, let me do this. This witness is a big witness for the hospital. The hospital needs this witness to be believable. They really do. Because what the witness says is, the witness says that when Maya was there, she was observed happy, go lucky. The feet were not pointed in, that she didn't complain of pain. Now, the weird thing about this is this with CRPS is not inconsistent with CRPS. CRPS, complex regional pain syndrome, isn't one of those things where, you know, they're not going to ever experience happiness or joy. They're not going to ever be able to pick something up or move. There are flashes up, flashes down. People have, I mean, imagine like the concept of hot flashes, right? So it's a sudden onset. It's not there. It's there. It's not there. It's there. It's not there. Okay. So if you were to think of it like that, there are times that are good, times that are bad, which makes monitoring and proving Munchausen by proxy that much harder. So this witness's testimony is critical to the hospital, but can also be somewhat dismissed by the plaintiffs based on what we know about CRPS. So the hospital needs this witness to be believable because the witness testifies to a lot of observations. But there's a lot of hearsay in here too. So listen to her testimony.
What did you do with the chocolate cake and the food items in the refrigerator, ma'am?
Seeing as the child protection investigator supervisors advised us that no outside food was allowed, that food was also taken that day.
And hearsay, I move to strike.
Overruled.
Oh, Anderson is on.
And Ms. Niehus, can you please
Mass
tell the jury
defensive.
what items were not allowed in during this first visit? If you could list them off for the jury, please.
She was not allowed the cheesecake, the cell phone, the iPad, and the communion.
Thank you.
And I asked you about the refrigerator. Where did you take the items from the refrigerator again?
All of the food items and everything that I confiscated, I turned them over to the child protection investigators at their office.
At a certain point, did you come to learn that Maya had given her father some letters that she wrote?
I did.
What did you do with those letters?
I defaulted to the supervisors on what I was to do with the letters. I made copies of them and took photos of them and advised that they would have to be looked over by the supervisors, the child protection supervisors and my supervisors before they could be given to whoever they were addressed to.
Did you have an opportunity to view Maya Kowalski and observe how she was moving around, interacting with her brother and
There you
father
go.
during this visit on October 24, 2016?
Objection, lack of foundation, lack of predicate.
Overruled.
Overruled.
What did you observe in terms of Maya's ability?
That was trial tactics to scare the witness. That's what that is. So I told you guys I was going to be fair. I told you I'd be fair. That move by Anderson, that was a completely permissible question. There was nothing objectionable about that question. But we are now approaching subject matter where this witness can testify to things that are harmful to the plaintiff's case. So Anderson gets up and objects with a very long-winded yet nonsensical objection. He knows damn well it's no lack of predicate foundation. He knows damn well. The question was, did you have an opportunity to observe her while you were there? She's laid the foundation. It's there, my guy. Like, this is not a good objection, but it's strategically placed to alert the witness that we are about to get into subject matter where you need to be really fucking careful. Sorry for the vanity, but that's what it is. Anderson is putting this witness who's already high stress in an even higher stress environment. Anderson's like, I'm listening. If you go outside the bounds of what I think is proper, I'm going to object and I'm going to go jump down your throat. It's trial strategy. Defense did it too. They both do it, guys. They both do it. This is a helpful witness for the defense. Anderson is jumping on the objections. This is what we expect.
Ability to move around.
I observed Maya to move around freely. She was energetic. She displayed no signs of pain. She wrestled. I would almost describe it as roughhousing with her brother, trying to reach behind his back and roll him over to get a piece to this game that they were playing. They laughed. She twisted around kind of behind her from the hospital bed to the floor to get something out of a bag.
Did you have the opportunity to observe her legs in various positions throughout this visit?
I did. Maya's legs were always in the anatomically correct position like this.
At a certain point, did you come to see that there was a bottle of holy water and a bottle of holy oil in Maya's room?
I did.
Okay. Did you take the holy water or holy oil away?
I have to read my note. I honestly can't recall. It says that it was in the room and Maya couldn't tell us where that.
Objection, hearsay, that part.
Sustained.
Based on your observation, was there holy water and holy oil in Maya Kowalski's hospital room at All Children's Hospital?
Yes, it was.
What did Maya Kowalski tell you she was using the holy water and holy oil for?
Objection, hearsay.
Overruled on that one.
She said that she would take the water and oil and she would make the cross on her hands. And sometimes she said that she rubbed it on her arms and sometimes on her legs, but it doesn't always make her feel better. I'd asked her where it came from and she was a little uncertain. First she said it came from Poland, And she said her mom gave it to her. And then she said a sister from Venice Church gave it to her, but she was uncertain between the three which one exactly gave it to her.
Did Maya Kowalski describe any of the types of activities that she was participating in at the hospital, All Children's Hospital, as of this first visit?
I believe she stated that she was participating in arts and crafts.
At any point did you come to learn about her participation in music therapy at All Children's Hospital? It's towards the bottom of your first page of your note.
Yes, she does. She did tell me that she participated in music therapy with a staff person by the name of Mrs. Kelly.
Did Maya Kowalski give you any?
The court feed, court TV is playing with the mics. So when court TV hears that they're catching whispers from counsel table, they just auto gain it down, like to try and not catch that, but it messes with the volume all over the place. She keeps reading instead of refreshing. She does, but so did the plaintiff's witnesses.
Any description of the type of view that her room had at All Children's Hospital as of this visit?
She was very happy for her ocean view room.
At any point did you have the opportunity to observe Maya and her father use the bathroom?
Why did that answer bother the hell out of me? Why did that bother me that damn much?
Bottom of your first page of your note.
Yes, she does. She did tell me that she participated in music therapy with a staff person by the name of Mrs. Kelly.
Did Maya Kowalski give you any description of the type of view that her room had at All Children's Hospital as of this visit?
She was very happy for her ocean view room.
At any point did you have the opportunity?
Okay. Body language is not a science. It is instead I'm not going to get into it. I'm not going to get into it. There's a whole lot of contempt. Like a whole lot of contempt that just I say this because I don't care whether you believe me or not. I don't care whether you think body language analysis is bullshit or what. I don't care. It doesn't bother me. Here's the thing. Humans are perceptive of other humans. If I am perceiving that, I can guarantee you that there is somebody in the jury that might be perceiving that same thing.
Opportunity to observe Maya and her father.
And that wasn't depot scarring. That's not depot scarring. That's not deposition scarring. That's not cross. That was that. And the reason I paused, that was a question that was about Maya and her room. That's not depot scarring. What question in a deposition could have triggered that level of defensiveness, that level, and the way she answered it was that was disturbing. I didn't like that.
Use the bathroom.
Yes, he picked her up out of her wheelchair, carried her to the bathroom, set her on the toilet, and he came back out of the room. He did not assist Maya with undressing, nor did she ask for assistance with undressing. While she was still in the bathroom and she finished, I heard her wash her hands, and she was able to reach the paper towels, which was a little higher up in that bathroom, and she did not ask for any kind of assistance.
That's important. That's a suggestion that she was standing. So that's important.
Did you ever have the opportunity on October 24th to observe Maya eating food?
Yes.
What do you recall about that?
Maya seemed like she always ordered grilled cheese. She had grilled cheese, I believe, chocolate cake every time I was there. I have to look at my note here. Yeah, it was, she wanted to keep the tray in her lap. She ate her grilled cheese. She had said again that Dad had brought her chocolate cake prior to one of my visits.
Approximately how long was this first visit?
I think it was a little longer because we ended up being a little late.
3
It was
hours,
just over an hour, maybe an hour and a half.
an hour and a half.
And after the visit, tell me a little bit about what you and your office did with some of the letters that you had received from Maya Kowalski during this visit.
Could you say that again, please?
Yes. After this visit, can you tell the jury what you or your office did with respect to the letters that you had received from Maya Kowalski during this visit?
We were advised by the child protection supervisors and my supervisors to take copies of the letters and photos of the letters, which a staff member at the hospital, I believe, assisted us with making copies. I took possession of all of those items, the food items and the letters, and transported them back to the Safe Children Coalition. And then I transported them along with my supervisor to the Child Protection Investigators building and turned them over to.
All right, let's get the cross to avoid a full-on 3-hour stream.
Let me turn on the system there. I will send it. Thank you. Thank you for doing that. Okay, looks like everything up and on. Yes. Ms. Crowells,
Judge, I don't have anything about this witness, but if we have time to do exhibits, there are a couple we would like to try to put in.
we have about 15 minutes.
Great. So going back to.
Although I do need a clerk.
We do need a clerk. Just remember this. We're going to be looking at the list from yesterday that we never got to, Judge. The one from October 16th, 2023.
Sure, I got that one. But you can go on.
Yeah, I'll just tell you. So let me know when you're ready.
I'm ready.
So we would like to put in exhibit 3047. It's the Tampa General Hospital, July 30th, 2015 admission. The objection was that we didn't specify which pages. We're putting in the whole, it's a medical record of her admission to Tampa General for that month, and we're putting in the whole record.
So 1,448 pages.
Correct.
The TGA regularly asks them for page numbers because some of it is admissible, but most of it
Funny moment coming up. Funny moment coming up.
is based on, not most of it. There are significant portions that have hearsay within hearsay with no exception. Further, they have, quote, they're not even diagnoses. There's a lot of speculation contained therein by people who have absolutely no background training and experience in trying to state whether or not it was a particular diagnosis, conversion, Munchausen, CRPS. None of them would ever pass Dalbert. None of them would be allowed as experts or even as treating physicians opining on that in this case. And so our problem with them is that they're going to be excised of the hearsay within hearsay without exception, and they need to be excised of any, quote, opinion by people that don't know enough to make that opinion. That's why I asked for the page numbers.
Well, okay. We want to put in the whole record. It's the hospital admission for the month. She was a Tampa General that has been talked about significantly with this jury. We're going to be reading depositions and applying depositions of doctors from the Tampa General Hospital record. But I mean, it's her admission, just like the Johns Hopkins, thousands of pages came in. It's the record of her admission to this hospital. I don't know how to designate specific pages the record's coming in. It's a medical record.
From my perspective, it seems like the jury is already aware that at Tampa General Hospital, there was some attempted diagnoses that are unfavorable for the plaintiff. I think they already know that. I don't see the problem in just putting in the
records come in. There might be hearsay within hearsay, but that gets redacted. So I get his point. His paralegal's not there with the notes. I get his point. But you have introduced full ass files of all the records. This is what's good for the goose is good for the gander.
medical records. Is there something specific you want me to look at, or?
There's quite a bit, but A, I didn't know we were going to do this today. B, I asked him to narrow it down so we could talk a little bit about what these specific areas that I wanted to go through that I was concerned about. I think we gave them some of them, but again, I wasn't involved in that.
We have a list prepared of the hearsay within the medical records. However, we weren't on notice that we were discussing this exhibit at this point. So
Which I
we
did
were prepared to do it yesterday, but our paralegal with that list has just departed for the day. So we're trying to get all the list so we can discuss it in a more informed fashion.
Well, then this is going to go well, Judge. The other exhibit we want to put in is the
Thank you, Blessed in Texas. Hit the little thingy to enable your gifted memberships. There's a lot that are flying around like all over the place. Thank you. No, no one's blocked in the stream. No one's blocked, you guys. We don't block people for doing that.
Laurie Children's Hospital record 3032, which is only 249 pages. But again, it's the admission to the Laurie Children's Hospital from 2011 to 2015. They're clearly relevant. They're medical records, and we'd like to put them in.
The same objection, Judge. Yes, a lot of them are statements for the purposes of medical analysis. That's an exception to hearsay. But there's also a tremendous amount in there of just back and forth of people that they're not talking about, particularly any of Maya's statement about medical treatment. And again, there was a ton of just sort of thrown out opinion in there, including from nurses and physical therapists and people that have no background training or experience and would never be allowed in court of law to form a diagnosis on any of that.
Well, the reality is, I mean, I'm not offended by the concept of putting in medical records.
Okay.
And so what I'll do is I'll give you the opportunity to get your paralegal to have a specific discussion. If you can point to specific pages that you're talking about, I'll look at that. But as a general rule, medical records, I have no problem with them coming in.
And we stipulated to an awful lot of them, Judge.
Not these, because they're on our list.
Well,
They're on the-
I will say that the continuation of whether things are stipulated or not is continuing.
Okay. How about 3048, the Venice Regional Medical Center records?
What's the
This is
date?
Dr.
What's the date of admission?
I'm sorry, I don't think I can do
Is this Dr. Mendez or Melendez?
Venice Regional Medical Center.
Is this Dr. Melendez?
You're asking me a question, you can't answer, Mr. Anderson. I'm looking for it. Okay. Let's get that one.
Oh, if this is a reference to Nick, you know, it's fine. That's cool. I love Nick. Nick and I are good friends. It's okay. Different cups of tea. We all have different cups of tea.
How about 3035, Moore's Children's Hospital records?
Is all of this having to do with the same paralegal who's not here?
How many pages is in the board record?
253.
Yes, Your Honor.
Part of it's in a couple pages of it that were relevant material and discussed.
Oh, yes, yeah. Let's get that.
Laurie Children's?
How about Dr. Mendez records, 3031?
So we're still on everything from yesterday.
Yes, these are all medical records. We're going to play depositions, Judge, today of medical doctors. One's from Tampa General, one's from, I mean, I don't think it's critical that they go in before we play the deposition being shown. Yeah, but we'd like to get them in. So I guess we're not going to get any of that accomplished right now.
Okay. Mendez is a whole category unto itself. And we would object to portions of his deposition. I have objected, although the court may well have overruled this for all we know, because I haven't checked the specific point. But our concern here is that this is an allergist who, after meeting with Maya Kowalski for approximately 45 minutes, comes up out of the blue with this must be Munchausen by proxy. Even though he can't diagnose, has no idea about CRPS, has no history, has no basis whatsoever, he just throws this out there. And that's the kind of thing that 403 was meant for, were these kind of circumstances where someone with no qualifications and no background training experience, no foundation and no predicate in terms of investigating this, just starts throwing out a diagnosis in an area that he clearly has no clue about. So we object to his testimony coming in on that. He's a walking Dalbert challenge.
Judge, it's a treating doctor.
Okay. That doesn't. At some point, the defense is allowed to defend themselves.
Why?
I know that was said tongue in cheek.
Okay, that was one of my favorite moments. That was one of my favorite moments of all of today. That was one of my favorite moments from all of today.
Will reflect that everyone's
Coming
My
in on
favorite
that.
moments.
He's a walking Dalbert challenge.
Judge, it's a treating doctor.
okay.
That does.
At some point, the defense is allowed to defend themselves.
Why?
I know that was said tongue in cheek. So the transcript will reflect that everyone's laughing. The reality is, if he was a treating physician and has observations of Maya or the mom, then those are going to be relevant for the jury. If you feel
It's the right
he was
call.
inappropriate with his diagnosis, I am confident you are going to excel with your cross-examination.
Thank you.
Excel with his cross-examination. So without further ado, we'll do a swoopy swoop and get to the cross-examination. Swoop. Cross-examination.
But
Oh no, why are you doing spinning wheel? Don't do spinning wheel. Come on. No.
okay. We're going to get the witness, is that correct? Yep. The deputy went, yeah.
This cross gets, this is a good cross. This is a damn good cross. It's a damn good cross.
Well, welcome back.
Back to you.
Thank you.
How was your lunch?
It was very short.
Oh, well, sorry to hear that.
At least I got about 4 bites today. So I want to confirm you understand you were still under a
Good on the witness, though. That was nice.
Mr. Anderson, you may begin your cross-examination.
May it please the court. Ms. Niehus, on direct examination, you testified that you never saw Maya in pain. Is that right?
That's correct. And it's
And you also
Niehus.
testified, if I remember correctly, that you put everything down.
It's Niehus.
I'm so sorry, Ms. Niehus.
Thank you.
You put everything down of significance in your notes. Is that right?
I put down everything that I witnessed and saw.
And you had in fact previously testified that somebody saying that they were in pain is a sign that they're in pain. Have you not?
Say that again?
You have said previously that someone saying they're in pain, that they are in pain, is a sign that they are in pain. Right?
I don't believe I said it like that, no.
Well, remember your deposition of November 18th, 2020? You were sworn to tell the truth. You remember that?
Vaguely.
Right. And I asked you a series of questions about how much you knew about rating pain. You recall
You
that?
say rating pain? Yes.
Page 130, beginning at line 9. I can show it to her if you want.
Sure.
Yeah, approach. You may. Good, ma'am. Read from yourself. Line 9 there. Down to 8. The next page.
Says, line number 9, says, question, are you telling the jury that your ability to ask somebody? Oh, sorry. I never stated that I was an expert.
If you look at 3 questions before that, you said you had training.
I do. I've been trained, yes, with the
And-
EMTI.
And when asked about that training and what it was that let you know if someone was in pain by that training, you said by asking them, right?
That's one way to ask somebody if they're in pain or to find out, yes.
Right. And the response then, according to you, would be relevant as to whether or not they're in pain. True?
That could be true.
Mike?
Do what? Is this better?
Yes.
Now, if I may, I'd like to, if I may approach, Your Honor?
I think she already has a copy of the deposition.
No, this is the deposition, excuse me, Your Honor. This is the Safe Children Coalition Visit Observation Form from October 24th, 2016. Am I?
Did she sell the copy?
Yeah.
You have a copy of that?
You're great.
He's got copies here.
We got 4 copies here.
Mr. Hughes has all 4.
Yeah, I'll send all 4, good.
Okay. Go ahead.
Thank you.
May Mr. Whitney approach? All right, so, ma'am, if you would turn to, I think it's the 3rd page in, and tell me then whether Maya told you on 1, 2, 3, 4 occasions that she was in pain.
Where exactly?
All right, well, if you look at the bottom of the first paragraph here, not the half one on the top, the last 3 lines on the top paragraph. Kowalski asked Maya how she was feeling.
You said the 3rd page, correct?
Oh, I know. I'm sorry, Your Honor, I'm just trying to orient the witness.
If you need to, you can approach her and point it out.
All right.
This is the 3rd page. Mr. Kowalski asked Maya how she had been feeling, and she stated not good, and I asked her what not good meant. She stated that she meant she is hurting. I asked her where. Maya stated it all over. The father lifted Maya up out of her wheelchair and placed
We got reading into number 2 here. If you look, that's the beginning word there.
on the list for the next visit.
Yes, you say.
Maya pointed to her right forearm, stating her old IV site hurts bad.
Down on the bottom here, last 3 lines.
Maya stated that she attended physical therapy.
We'll object to the extent we're having witness read something that's not evidence.
Let's reviewing your notes, refresh what you saw and heard.
Yes,
And in declaration of pain.
This is a really hard area of law. really hard area of evidence. So refreshing recollection. One moment. One moment. Refreshing recollection. When a witness is on the stand and it seems like they're struggling to recall specifics of the event, I can use something to refresh their recollection. But if they're testifying off of the document, it's still hearsay. So I can use anything to refresh recollection. I can actually walk up to the witness and say, does this pen refresh your recollection? Does this Stanley mug full of water and emergency refresh your recollection? You can say anything, but they have to testify from their recollection. They can't read it. The problem that you run into is that no one explains this to the witness. No one explains it to the witness. No one explains it. So the witness is going, I don't know what to do. What do I do? Do I read? Do I not read? Do I look down and I testify? I really wish they would come up with a better instruction for this particular allowance in evidence. It is really terrible. It's like it just say you can refresh your recollection off of the document, but you can't read from the document. So you can glance at the document and look up to us and tell us if you remember what it is you want to say. Frustrating.
Ending number 3. Does it refresh your recollection that Maya stated the parallel bars hurt too much?
Same objection.
Just let's finish this. Go ahead and answer the question.
That's what you said, physical therapy, yes.
Top of the next page, second and third line down.
What did you want me to read?
Well, just read to yourself, if I may, Your Honor.
I'll just point it out for our situation.
No, I see it. What do you want me to read?
To yourself.
We will object to having a witness read.
And what I want you to do is,
Yeah.
you can read your note, if it refreshes your recollection of what you saw and heard, and then answer his questions, hopefully without reading your note.
Okay, what is your question now?
Would you agree with me now that at least 4 instances in your report, Maya Kowalski stated either she was in pain or that she was hurt or hurt?
She stated that the physical therapy to help her was hurting her, yes. And she stated that she sometimes sleeps and wakes up with pain.
And more than that?
And then what?
And more than that?
What do you mean and more than that?
An old IV site
Oh, the old IV site that she got in Mexico.
really hurt?
She didn't say really, she said that it hurt.
That's not an IV site, ma'am. And then,
That's exactly what she
then on
said.
the bottom there, what is it? Does it refresh your recollection as to what Maya stated about whether or not she's hurting?
In the last paragraph?
No, ma'am. The bottom of,
You could go and
so again,
You're on a different page.
This fighting does not come across well to a jury or a
Can I just
judge.
read this?
overall, you can finish.
This is the same thing I just read.
does this indicate again that Maya said she's not doing good, that she was hurt?
This is all about refreshing our recollection.
Is your recollection refreshed?
Yes, this is what I just said that she said.
So Maya did state she was in pain.
She did. However, she didn't display any signs of pain. Not once. She played like a normal little girl.
But if telling you you're in pain is a sign of pain, she gave you 4 different signs she was in pain. Did she not?
She stated 4 different times that she was in pain. Physical therapy that the hospital gave her to help her. She stated that she was in pain from an old IV site that she got while she was in Mexico. She stated
Guys, we're not going to do this. Come on. Come on. Be critical of the testimony, not the person, man. Critical of the testimony, not the person, whether she's believable or not, whether she's lying or not, whether you believe the thing or not, whether she's hostile or not. Critical of the testimony, what you're seeing, not the person.
that she woke up in pain, and she stated, I can't remember what the first thing was, that she hurt. However, just somebody saying that and not showing you any signs or other symptoms that she's in pain is not an actual portrayal in my EMT profession to be the whole picture of pain.
Ma'am, all I ask you is whether 4 times Maya expressed that she was in pain in your report of October 24th.
I said yes. I read them to you.
Let's look then at your next one. We might, your October 27th report. May I approach you, Mark?
You may.
On the second page. Bottom of this paragraph. See here?
Mhm.
Does that refresh your recollection
We can
that
look at body language and
Maya
comment
said
on
she
body
was
language
pain
all
all
you
over.
want.
Maya did say that, yes.
Let's look again at the next page. Bottom paragraph here.
I documented that the RN nurse,
Let me ask a question. Does that refresh your recollection that Maya mentioned
Okay.
that she was in pain when you first arrived?
say that again?
Does this refresh your recollection that Maya told you when you came in that she was in pain when you first arrived?
Maya did not mention any pain throughout the visit, except for when we first arrived.
Right. And somebody came in to give her.
Except for when we first arrived. Except for when we first arrived. We first arrived and she experienced pain. Stop fighting him. Stop fighting him. By fighting him, you are making yourself look less credible. Stop fighting him. Why are you fighting? Stop fighting him. Because every time you fight him, every time you answer a question before it's out of his mouth, every time you get snippy and read a question or read something off the page before the question is asked, you look like you're lying. Every time you do that. Every time. Good comment in the chat. She's forcing Anderson to be a dentist. Don't make me pull teeth. Don't make me pull teeth. I don't want to pull teeth. It's a pain in the ass. Answer. Just answer. Everyone's saying pause game on point. Pause game is on point. She hates these questions. I get it. I get it. She hates the questions. You have to answer the questions. Why are you fighting this? Your testimony is your testimony. If you saw her playing, you saw her playing. There is a world where that testimony fits in with both the plaintiff's case and the defense's case. There is a world where that makes fucking sense. Stop trying to skew it.
Tramadol. Do you know what tramadol is, man?
I do.
That's pain medication, right?
Correct.
And during the course of this, did you have Charlotte Laporte, sorry, with you?
At this visit,
Yes.
I do not believe Charlotte was with me during this visit.
All right. So during the November visit, was she with you? Do you recall?
Okay, we have too much cross to get through. We're not going to get through all of it. I promise you. I know it gets spicier, but it's so much faster, and we have to get to the jury questions. So we're going to go ahead and fast forward to the jury questions. Sidebar on the record. Oh, they have. You know what? Oh, wait, hang on. I got to back up. On the record, this one, there are some good comments here. Hang on.
Members of the jury, do any of you have any questions?
Yes, they have questions. Of course they do, because that was a that cross did not have to be that painful. That cross did not have to be that painful.
The jury, in the light of the number of questions, I think what I'm going to do is have you go into the room. Not discuss the case amongst yourselves, you have to do investigation in this room.
That did not have to go that way. Answer the questions. That did not have to go that way. Man, and now the jury is sitting here. Here's the thing. Now the jury's here, and the jury has.
Me plus us.
Yes, I have you wait just outside.
Do you want me to leave this here?
Yes, ma'am, you leave all that.
Did she just correct the judge on her name? Okay. Well, fine. Niehus.
The witnesses now out of
I'm gonna try.
presence are going to have to come up so you can look at the paperwork. But the first question in the Harley Quinn picture, how many charms are on that bracelet? Did you see evidence of lesions or abrasions at the point of contact? Okay, so red number 2.
Sorry, guys. I was hitting mic.
What was the reason the observations were stopped?
I don't know if they were. She knows, but ask her.
I don't just get to a court order, Judge. I don't know.
There's no court order on that.
Her observations, or are we talking about, I don't know if the question was asking her supervision or the observations that were being made by the video recording allegedly.
No, Judge, my concern is that asking why she stopped going, she only went for 4 visits. I think that doesn't court orders.
I think this has to do with her observations. Why did she stop doing it? Do I ask a series
We'll
of
get
questions
there.
about for over the course of 2 weeks?
Well, she was brought in to talk about her observations. So
I don't
the
know.
fact that she stopped coming, if it was at the behest of the dependency court or the DCF or
I don't know why, I don't know the answer, Judge. Because of the court's ruling, it's just raising this factor that I don't know what her answer is going to be and possibly be entering into that.
Whether she was going to be able to go back to
I'll think about that one. Let's go on to the next one. Red number 3, you were asked on your observations of Maya and gave your description. Are you asserting to this juror that during that first visit that Maya and Kyle and possibly Jack were
There it is again. There it is again. Are you asserting to this jury? Are you asserting to this jury?
occupied with themselves in a, I think it's giddy, in oblivious way while your team searched through the room, bags, fridge, and confiscated items and removed items? Or was there any signs of questions or resistance from Maya/Jack?
No objection.
Yeah, we object. This is argumentative. It asserts facts, not evidence. It goes to
Yeah, it's argumentative.
DCF perceptions are in terms of what was taken, what was not.
Well,
This
the
goes to-
biggest concern, I'm sorry, is that this is this juror's interpretation of evidence, Judge.
No.
And they're confusing things between the first, as to who removed stuff.
The defendants brought out that information, and it was an issue before the jury as to their ability to observe it. And it's a factual question. How were they reacting to her going through the room? And it also goes to her ability to perceive things if she's preoccupied doing that.
I'm going to overrule the defendant's objection. I will ask that one.
Yes.
Let's move on to red number 4. There's a couple questions on this one. Your testimony for your 4 occasions to observe Maya portrays Maya as having some physical difficulties, but able to move about and get around via her wheelchair. Is that correct? So far in this trial, the jury has been presented with a plethora of photos and videos of Maya taken by both parents and staff at JHatch. Does your team, you, or the hospital possess any photos or videos to corroborate your testimony?
Guys, that is a different juror. Do you think the jury has some opinions already? I'm not saying whether this is right or wrong, but what this is telling the hospital, this is the mountain you have to climb. This is the mountain you have to climb. Like you gotta be up here. Like you gotta be up here. Where you're like down here. You gotta be up here. These questions are cross-examination. Holy crap. The jury did. The jury's like, prove it. Jury's like, bet. This is a, if there's any questions as to who has been controlling the courtroom dynamic or how the jury might be thinking, and I have thoughts on this. So look at your screen right now, right? So you have Anderson that's up there, then you have Crowell's, Shapiro, and then Hughes. They're right there for the defense, right? So the jury, even though the jury's not in the room for this discussion, the jury has observed all these different attorneys speaking on behalf of the defense. Well, one of the comments I've been making about Mr. Anderson is that he's the only one that's standing up for every witness. Mr. Whitney, little things here and there, but Anderson's been the one standing up for almost every witness. The defense is changing out fighters. Like the defense is bringing in different defensive line. They keep switching out defensive line, same quarterback here for the plaintiff. Okay. So it's one of the thoughts that I've been having about this and going, why is Anderson doing this to himself? This is brutal. I don't just mean like brutal. This is brutal. The prep you have to go through to direct examine and cross-examine a witness is remarkable. And then to do that for 5 witnesses, insane. Do that for 20 witnesses. You are now at a level that, how? You cannot prep for that. Especially when you have 2, 3, 4 depots that have been taken before this. So Anderson's been doing almost all of the witnesses, both direct and cross. And I will comment, he, like I said, he is far better in cross-examination than he is in direct. Direct, Mr. Anderson, you got work to do, bud. You do. Cross, you got it. You can do it. Good. But what this is portraying to the jury, the portrayal to the jury, and the way the jury is looking at this, the jury is looking at this witness with a very skeptical eye. I'm not saying whether you should or should not believe the witness. I have no reason to believe or disbelieve them. What I'm saying is the jury, by their questions, are indicating to you that they have a very skeptical look at what this witness is saying and the witness that preceded her. So the jury has bought into the plaintiff's case, at least for right now. And after that first witness, Ms. Laporte, I thought the jury would back off. I thought the jury would hear Ms. Laporte and basically say, okay, there might be questions. Can we like tone it down a bit? No, they went further. They became more intrigued, more argumentative, more cross-examining. And I thought about this, and I think a lot of this plays with this idea that you have Anderson that's up there, every witness. And is he missing points? Yes. Is he making things that are like arguments that shouldn't be made? Yeah. Is he taking forever to get through direct? God, yes, he is. But is he portraying a theme? And did that theme catch on with the jurors? One attorney versus the whole desk. Because it's been Hughes, it's been Shapiro, Crawls. Who's the other one? Hughes, Shapiro, Crawls. It's another H. Hunter. Boom, 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 boom. Every time. And they switch off. So this is a message that gets sent. The jury perceives it. I don't know whether it's the right call or bad call, because the problem is that at some point in time, Anderson's human capability is going to stop. Like, you're not going to get to that point. Oh, and then Attenberg. So it's a strategy. It's a risk reward thing. Judging by this, you guys tell me, is it playing off? The jury seems to think so.
No objection.
You said
Please tell me that my stream didn't just glitch during that. I'm going to rewind for a second. So, juror number 5. Juror number 5.
red number 5. Well, there's a parentheses. A fellow retired law enforcement officer inquires in parentheses. You several times referred to a reported, quote,
Called it. Called it. Called it. Retired law enforcement. Oh, God. Called it.
pain, end quote, was from an old Mexico IV. Am I incorrect in believing that whatever pain is being reported by Maya should be documented and acted upon? Or am I to then believe, quote, old injuries, end quote, are not to be considered in Maya's case? Please educate me as to the proper train of thought I should be in.
I don't think that's a question for the juror.
I think that's a real hard one, Judge. I think that's appropriate.
So it sounds like both are objecting and the court will sustain. So I'll just give that one to you right now, Madam Clerk. Red number 6. Is it your testimony that a young girl is, quote, happy, end quote, to be away from her family in a hospital? Or is she happy to be happy? Yeah. Or is she happy to be having a visit with her family? Next question. Are you saying that a person is not in pain if they say they are in pain if you do not think you see symptoms of pain? As a person that works in the healthcare profession, are you not to believe what a patient says their pain is?
did you not say her room was completely organized? In the photo, we just saw the couch was not organized, neither was the floor or her tray table. What part of her room was organized?
All fair.
Objection.
Red number 7. First question, did CPI check investigator Beata before taking Maya, and what did they find? Next question, do you know what
Okay, I just wanted to get the former law enforcement officer. People are asking, what did I call? I called that there was a former law enforcement officer on this jury. I said there's retired law enforcement on this jury. So, yeah, that was with the questions being asked, it sounded like law enforcement. So the jury's cross-examination of this witness is worse than Anderson's. Far worse. So
one grab the witness? The jury has a whole bunch of questions, but there's one I want to hear your answer to before I bring the jury back in.
Oh no, I don't want this one. Hang on.
Feel free to sit down.
Okay, thank you.
What was the reason your observations were stopped?
Oh, I believe the case transitioned over to where there was a case manager.
It's a
Andrew
proper
Hassan,
answer.
so-
So we can go forward. Jury, please.
No objection.
Okay. I'm going to just remind you.
And yes, I'm monitoring the time. I'm going to have to start speeding things up. I need to get to the last witness, though. I need to get to the last witness. I need to, because the last witness is very favorable for the defense, and we need to hear from them. Come on, jury.
Members of the jury, I want to confirm, while you were away, you did not discuss this case amongst yourselves, you did no investigation, and you received no information. Is that all correct? Correct. And that no one approached you about this case while you were away on that break? Correct. And you did not see
Oh,
any
Jeff.
write-ups about this case?
Just wait until she answers the jury questions.
And ma'am, the jury has a
Jury
series of
asks
I
questions.
just want to remind you of this.
She has thoughts.
The first question, in the Harley
Look to
Quinn
whom
picture,
she directs those
how many
thoughts.
charms are on that bracelet?
I would have to see the photo again.
I don't bring up the photo.
People asked about the charms on the bracelet. How many charms are on the bracelet? Was that asking about the bracelet? No. What it was it was going to show Maya's feet, because the testimony from this individual, Miss Niehus, was that Maya was wearing heels. So some very astute juror said, how many charms were on the bracelet? Rather, the anklet. Yo, jury's playing chess. Jury is playing chess. And I'm sorry for doing the yo thing. That sounded weird. That felt uncomfortable. The jury is playing chess.
On the bracelet?
She testified those were heels. So, jury's playing chess. By the way, I love the Harley Quinn outfit. I didn't like they called it Harlequin. It's Harley Quinn.
Apparently 005.
Are you speaking to the ankle bracelet?
I guess so.
I cannot tell.
Well, here's the next question. Did you see any evidence of any lesions or abrasions at that point of contact?
Where her bracelets are? No, I did not.
Next question. What was the reason that your observations stopped?
Because my position with the Safe Children Coalition, the case had transitioned from CPI to the Safe Children Coalition. So my services as a safety manager were no longer needed. It was assigned to somebody else.
The next question. You were asked on your observations of Maya and gave your description. Are you asserting to this jury that during that first visit you had, that Maya and Kyle and possibly Jack were occupied with themselves in a giddy and oblivious way while your team searched through the room, bags, fridge, and confiscated items and removed items? Or was there any signs of questions or resistance from Maya or Jack?
Can you read that again, please?
Are you asserting to this jury that during that first visit that Maya and Kyle and possibly Jack were occupied with themselves in a giddy and oblivious way while your team searched through the room, bags, fridge, and confiscated items and removed items? If you can answer that.
I can. They were enjoying themselves, playing, having a time. Her and Kyle were wrestling. I would call it keep away from this one toy in the game. I would not describe my teammates and I searching the room in any kind of way that it was asked there. It was a casual open the refrigerator door as safety managers and child protection.
I cannot get over the fact that the jury is now referring to themselves in third person. I cannot get over that fact. Are you asserting to this jury?
Investigators, it is a standard practice to open up a refrigerator anytime you enter a home or area where this child's safety might be in question. It was just more of a open and shut, and the items that he brought with him, that was handled outside of the room.
Was there any signs of questions or resistance from Maya or Jack?
No.
The next question. Your testimony for your 4 occasions to observe Maya portrays Maya as having some physical difficulties, but able to move about and get around via her wheelchair. Is that correct?
My observations, I strongly believe that she moved around freely without limitations.
Thanks, Rosebud.
So far in this trial, the jury has been presented with a plethora of photos and videos of Maya taken by both the parents and staff.
Again, the jury is referring to themselves in the third person. This is so weird.
Johns Hopkins All Children's Hospital. Does your team, you or the hospital, possess any photos or videos to corroborate your testimony?
They're asking if I took photos to corroborate my testimony?
If you or your organization have photos that corroborate your testimony?
I took photos of the letters and the checks and the food. I photographed the refrigerator. I required to take a picture of Maya to upload into the state computer FISBIN. And my notes are very, very detailed. I took a report writing class in college, and I was assigned to just document everything that I saw, whether it was just some minute detail or something of importance. I just documented everything that I saw. I did my job and what I was assigned to do by Child Protection and the Safe Children Coalition.
Next question. Is it your testimony that a young girl is, quote, happy, end quote, to be away from her family in the hospital? Or is she?
Is it your testimony? My God. These are not the jury questions that we heard for any other witness. For any other witness, these are not the questions we heard. This is the jury. Their impressions of this witness could not be more clear. Could not be.
Is she happy to be having a visit with her family?
Maya stated that she was happy to be away from her mother's anger on one instance, which is documented in my notes. And she was also happy to see Mr. Kowalski and Kyle.
Are you saying that a person is not in pain if they say they are in pain, if you do not think you see symptoms of pain? As a person who works in the healthcare profession, are you not to believe what a patient says their pain is?
Oh my God.
I'm stating that a person can say that they're in pain, and the person evaluating you would say, where? Does this hurt? Does this hurt? She would verbalize that, but she literally showed no signs of any kind of pain. She roughhoused just like my grandson, like your children. She did all of that, and I don't want to say never. I do not recall her ever once saying, ouch, don't do this. Kyle, get off of me. Hey, let's not wrestle and do this. Mr. Kowalski did not stop this roughhousing. He just let it go on. When I thought that her safety was in question when she bent way down to the floor, Mr. Kowalski didn't state, hey, don't do that. You could hurt yourself. None of that happened. They were playing like brother and sister and happy to see one another. When somebody says they're in pain, you should also ask other questions or see other signs or symptoms of them being in pain. Doctor pushes on your abdomen. You go, ow, okay, that's that. They said they were in pain. Now it hurts here. So you need more information before you can state about all of this pain. She never once pushed her nurse's button and asked for any pain medication. In all of the visits, what did she state? Over 7 hours? She never once pushed a button and said, hey, I'm in pain. Can I have?
How long of an answer is that to that question? Ma'am. And this sucks because this could be depot scarring. I'm not sure. Like the whole testimony with the attorneys. And now she's realized that the jury is against her and she's trying to explain it away. But what she's doing now isn't helping. It's not. Like there is no way of objectively looking at this and saying this is helpful to the defense.
Have something. Absolutely nothing.
The next question from the jury. Did you not say her room was completely organized? In the photo we just saw, the couch was not organized, neither was the floor or her tray table. What part of her room was organized?
The part of her room over to the left side of the bed by the window, she had all of her shoes lined up by the chair and far under the chair. I'm not sure what photos they've seen.
Next question from the jury. Do you know what CRPS is and what the symptoms are? And have you been trained on how CRPS pain reacts to patients?
I am not a doctor. I've not been trained in CRPS. To be honest with you, I would have to sit down and Google it. It's a complex pain disorder. I know a very, very basic knowledge of it. I believe it stands for chronic repetitive pain syndrome. That's my basic knowledge. I would have to Google it.
I missed this part during my first watch through. Chronic repetitive pain. No. I have heard it referred to as chronic regional pain syndrome, but its proper diagnosis is complex regional pain syndrome. Why are you explaining this away? Now the jury has just dismissed every single thing that you have said.
That completes the asking of the jury's questions. There were a couple I couldn't ask, but I asked most of them. Ms. Corrales, do you have any follow-up?
Just one. With respect to your role and observations that you made and that you documented in detail, you were there as an independent observer on behalf
Caution
of
fans with
CPR.
those pants.
Correct. That's correct. But
You were not associated with the hospital.
I'm absolutely not associated with the hospital. I was signed by Child Protection and the Safe Children Coalition, and I did what I was told to do by them.
Thank you.
Any further questions from the plaintiffs?
Yes, Your Honor. So you said.
Here's the thing. Anderson wants to go in and make sure this witness is not just. Anderson goes in for the kill shot.
That Maya, through all this, never complained of any pain. She never complained of any pain the whole time you were there, right?
I thought we just went over all of this.
Okay. What about when somebody touched her, like touched her leg or something? You testify that that wouldn't bother her?
I can't tell you what would bother Maya or not.
Isn't that what you just testified about? What bothers Maya and what does not?
I would not describe it as that, no.
Well, in fact, it sounded like you were almost making an argument rather than coming in as an independent witness, didn't it? No.
Sustained.
You felt the need to throw in every single fact you could possibly think of, regardless of whether or not it was responsive to the question, didn't you?
I'm going to overrule that one. You can answer that one.
I have no hidden agenda. I came in here and I described my job. That's it.
Isn't it true, in one of your reports, you documented that when one of the nurses tried to touch Maya's leg, that she, to test what pain level it was, she touched it lightly and Maya squirmed and yelled, "Stop it, it hurts."
I don't recall that.
May I refer?
You may approach the witness.
You want to receive impressions?
Yes.
Okay, please.
This is not my note, sir.
This is not
That's
your note?
Charlotte Laporte's note.
Okay, so why would Charlotte Laporte document that in her report? And let me show you your report from the exact same day.
Objection.
First of all, I object to the
Sustained.
last question. Answer me this second. He's referencing documents that are not in evidence.
The jury will disregard the question that Mr. Anderson started to ask.
Come on, Anderson. You won. Don't.
May I approach?
Yeah,
Why don't you show
yeah,
Ms.
please.
Correll?
Sorry, I thought we gave you all.
No, I don't know what, I can't see it from here, sir.
Anderson, you won. Why are you?
Why don't you all come up here?
Yes, Judge. Children. Please come up here. We need to talk about this. Children. See, Anderson goes for the kill shot here, and yeah, a couple of good points. He makes a couple of good points. When the witness's credibility is suspect, you go for that, but you don't have to go that far. Let me see. We got here. There we go.
Can-
Basis for the objection.
outside, so, and I'm not sure where he's going beyond.
I'll overrule that one question.
Would it refresh your recollection for me to show you your report of October 24th, 2016 about that issue?
Sure, you're welcome to.
Same one.
Oh my God. Sure, you're welcome to.
What page is that?
It's page 2. And it's right here.
Page 3?
In the middle of the second document.
I see it.
Does that refresh your recollection?
This is what I've already stated. I've recalled it and stated it.
So you do recall now that Nurse Lindsay advised you that you could get any film or video you needed from Sally Smith?
I stated this already.
Thank you. But you have none here today. How long have you prepped to testify?
When was our deposition?
No. How long did you prep for this testimony?
I didn't keep track of the time, sir. I'm a very busy person and work extremely hard. This is probably the last thing on my plate.
Well, how many hours have you spent any time with the defense?
Shit. Shit. If I'm the hospital, I regret calling this witness. Like entirely. This is. This is a shredding. This is annihilation. This is a shredding. Your witness has lost composure. There is no ability to regain that composure. You are not going to get your witness back on track. Right now, I've been here. I have been here. I have lost a witness down this track of where they're so ingrained in winning the argument that they will not stop. I have been here, and it freaking kills you as a lawyer to sit there and try while that witness is being cross-examined to object, to do anything you can to tell that witness screaming, focus, you are hurting yourself, please stop. This is shredding.
Anytime. We've communicated via email on what they needed. Had my deposition. I still had my deposition from before.
Ma'am, I'm just asking you the last few days. Have you had any
Yes.
contact with the defense counsel?
Yes.
On how many occasions?
I don't recall.
That many?
I didn't say that many. I just specifically can't state how many times.
Okay, so it was more than 1 or 2. Can the jury say that?
Yes, more than 1 or 2.
3 or 4?
I don't recall.
How many? Well, this was yesterday or the day before. You can't recall how many times you talked to the defense counsel about your testimony.
I
Is that
cannot
right?
testify under oath exactly how many times that I've spoken to them. More than 2 times.
Okay. More than 2 times in the last 2 days.
Is that a question?
Yes. Is it true? More than 2 times the last 2 days.
Yes.
Okay. And you were, I guess, critical of what? Maya for not asking for pain meds? That was part of your
I
testimony?
didn't say I was critical.
Well,
I did not state it was critical.
weren't you trying to point out to the jury that was part of your conclusion about why you believe she wasn't in pain? Was it she didn't ask for pain meds?
No, I said the whole picture over 7 hours of observing this little girl and her little brother.
Again, ma'am, all I'm asking you is yes or no. Did you say that? You can,
Folks, you have to let her answer the question. If you need to move the strike, you can move the strike. But let's give
No.
everybody the courtesy of asking a complete question and hearing a complete answer.
may the witness be instructed to answer yes or no to a yes or no question and then say whatever she wants after that.
I will ask you to actually answer the question that's asked.
Did you or did you not just tell the jury one of the things that concerned you about whether she was in pain was she did not hit the button to have pain meds sent in?
I cannot answer that as a yes or no because it's not just a yes or no question. I'm sorry.
Is it that you can't remember saying it here
No,
in front
I'm
of the
saying it
jury?
requires more description than just yes or no.
Well, the only question is whether in front of this jury, maybe it was before lunch, an hour ago, you said that to support your idea that Maya was not in pain.
I was
Did you or
not
did you not
supporting
in
an
here?
idea, sir. I was describing what I saw.
I understand, ma'am. All I'm asking you as a predicate question is whether you remember stating that before the jury here today.
Stating what?
And one of the reasons you thought that Maya may not be in pain was she didn't punch the button for the nurse to get pain meds.
The way you worded that, no, I did not say that. That's not how I said that.
Okay. Well, are you aware then that Maya Kowalski was getting regular doses of tramadol?
I can tell you that
Were you aware of that?
I was aware of one time.
Okay. So you think it was only on this one time? Is that your conclusion?
I'm not here to think. I'm telling you what I saw.
Okay. And what is tramadol?
It's a pain med, like we said an hour ago.
It's an
Mr.
opiate pain
Anderson,
med, is it
stop.
not?
Take mercy.
I don't know the definition of it. I couldn't tell you the contents of it. I know it's a pain medicine.
But in any event, Maya was receiving opiate pain meds during this period of time, at least once, right?
Maya received tramadol one time under my observation.
Do you know how much she took and when she took it in relationship to any of the scenes you report?
No, I can testify that the nurse came in the one time for tramadol.
And you were also concerned with Maya sitting crisscross applesauce, right?
With her saying that,
No, with you seeing that.
I observed and reported that she was sitting in an Indian style position, crossing her legs on many, many occasions.
And this proved to you what?
When Maya sat Indian style, she did not verbalize any signs of pain over and over the many times that she sat that way.
Do you have any training in physical therapy?
I would not call it training, sir.
Some.
I have been to many physical therapy appointments with patients and myself.
So you must be aware then, as two physical therapists have testified before this jury, that when a child has low back leg pain, that is the most comfortable position for them to avoid pain. Surely you know that.
Objection, argumentative.
Sustained.
It is
Do you know
argumentative.
that a child with low back, leg pain often sits crisscross because that is the best way to prevent pain?
I've never heard that. Nobody informed me of that.
And finally, I think you testified that you, on her ankle bracelet, didn't see any lesions. Did you check the rest of her body to see if she had any lesions?
Sir, it's not in my job description to investigate Maya's entire body. No, I did not.
So you don't know whether she had lesions or not.
Oh my
I do
God.
not.
Oh my God.
And so should the jury take then that you put everything as 100% accurate, right down to the tears in Maya's eyes?
I'm saying the jury should take into account that I spent over 7 hours with this little girl, and I documented what I saw in that time period.
And when you documented it, you got a lot of things wrong, didn't you?
When I documented it, my notes are wrong. I believe my notes are correct in what I observed.
Anything further?
Just one question.
You're gonna try and rehab that? You're gonna try to rehab that? You're gonna try and fix any of that?
With respect to your testimony here today and any conversations you had with the defense side, with the defense attorney, we simply were asking you to come in and tell the truth and testify what you observed.
Correct.
And is that what you did?
Overruled, she can answer.
And is that what you did today? To the best of your
Absolutely, 110%.
ability? Right, thank you.
Any follow-up on that one question?
No, Your Honor, that's not necessary.
Members of the jury, I see we've got more questions.
Of course they have more questions. Of course they have more questions. Why wouldn't they have more questions?
Okay, and members of the jury, just as a reminder, all documents that are actually in evidence will be back with you. Those that are not in evidence will not be back. Ms. Niehus, jury wants to know, were you paid to testify today?
Absolutely not.
So then we don't need to ask by whom or how much. And then that was the only question that I was actually able to ask. Defense, are there any further follow-up?
No, no.
This time.
May this witness be excused?
Yes, Your Honor.
Is she released from his subpoenas or she still need to be under subpoena?
Oh, she's running her ass out of that courtroom.
I would leave now. Okay, let's see here. We came back in at 1:40, so we're about an hour and 20 minutes. Do you have something really short or is?
We have,
Oh my God. What the fudge did we just watch? What was that?
I would leave now. Okay, let's see here. We came back in at 1:40, so we're about.
That was one of the most decimating cross examinations I have ever seen. Ever. And there's no saving that witness, because the thing is, the predicate to that was the jury questions. The jury prompted the onslaught. The jury was like, we don't believe you. And the jury starts asking questions. And then Anderson's like, oh, I smell blood in the water. Do not give a litigator the scent of blood in the water. My God. That was ruthless and relentless. And my word, I don't know that I've ever seen that. Now, I say all of that. Because the caveat is the next witness. This is what sucks. Well, not sucks. This is what's difficult about trial practice. You just had your witness slaughtered on the stand, and you needed that witness. But now you have a great witness coming up. But now the jury is like, I don't believe anything you're saying. I believe nothing. The ER nurse, doctor, ER nurse, I can't remember, was remarkable. Quite remarkable. K-Rab, thank you very much for the very generous super chat. This lady doesn't know anything about chronic pain. I was being evaluated once and said my pain level was a 10 plus. The person said that's not true. Well, that's a problem. If it were, you'd be on the way to the hospital. My answer, why? They aren't going to treat me. They'll accuse me of drug seeking. This is a problem with these stereotypes. We don't understand enough about these diagnoses, and we constantly talk to these people that are afflicted with this as if we don't believe them. This trial is an eye-opener for a lot of people. The only Latina, Anderson loves Maya. That's it. He'll defend her to the end. He also has it out for her because she knocked Beata for having a GoFundMe. Oh, this witness, yeah. When she also has one. By the way, Rob, you're hysterical. I'm tired and sick. Susan, does he know that she's not a nurse or a therapist? Why do her opinions even matter? Good question. That's a very good question. This is why I'm saying the defense is kicking themselves for calling her. The defense are the ones that went down the road of her opinions. The defense brought it in to say that in her opinion, based on her observations, Maya wasn't in pain. The defense opened that door. They said, we are going to bring this witness on to testify to Maya not being in pain because these are the observations. That allows for cross-examination on qualifications and whether the person had the credentials to make that opinion known. That's proper cross. It's painful to hear, but it's proper cross. KK, I understand her frustration due to her limitations slash scope as a CNA. CNAs are treated so poorly and disrespected. Their treatment's getting worse and causes agitation. I get this part. My problem is, why is she called to the stand to testify in this regard? If you are calling someone to the stand to testify to their observations, don't ask them to give opinions as to what those mean. Once you do that, you are setting your witness up to get slaughtered, rather attacked on the stand. This was a call by the attorneys. This was a bad call, bad move. Find another way to get the information in. Every ounce of progress the defense thought they made with this witness, gone. Rebecca, thanks for the coverage, Rob. Hard to follow the chat with the question. The chat is flying. People are gifting memberships. This is one thing about the chat. People are gifting memberships a lot. And one of the things with members, I can't slow the chat down for members. So when I slow the chat down, it slows it down for everyone who's not a member. Like if you see a 30-second pause and be able to respond, 60 seconds. I can't slow the chat down for members. YouTube doesn't give me that power. So the chat's flying because there's a lot of members that are participating live in the chat right now. Alex, this is a Dr. Spiegel to this trial. This felt worse to me. This felt worse to me. This felt. Would you like to have a jury ask things of you? Nope. I would not. I most certainly would not. I have been very clear. I am sympathetic to every witness that takes a stand, that they are placed in a position and a situation that is uncomfortable and not fair. They are asked questions. They don't get to express the true narrative they want to say. They are constrained by questions being asked of them. Being a witness is torture. It's torture. It is horrible to be a witness on the stand. Because you might know a lot of things in your head. You know who gets to control what comes out of that head and to the jury? The attorney in front of you and the judge that's ruling on the evidence. So you might want to say a million things and know them to be true in the deepest part of your heart, but you can't because the question is not being asked or there's objections preventing you. It is torture. I am sympathetic for every witness that takes a stand and every lawyer that's trying to guide those witnesses to the answers that they want to give. Trial work is remarkably complicated and emotional. It's hard to discuss. It's hard to go through, but we have to.
An hour and 20 minutes. Okay, members of the jury, let's go ahead and take a
break. Wait, do they do the, there we go, deposition. Spinny wheel, spinny wheel, spinny wheel.
Okay, let's see here.
We
came back in.
Like you should have a way of to enable
So
gifting.
we're about
I'm
an
sure
hour
someone in
and
the chat's
20
gonna help.
minutes. Do you have something really short or is?
We have 2 video depositions. One runs about 50 minutes, one runs about an hour 10.
So you heard that. Do you want to take a break now? Do you want to do the 50-minute one now and then take a break? You want 5 minutes now?
That's fine.
Oh, you want to do the 50-minute one? Okay, the jury is requesting to do the 50-minute deposition. Am I hearing that correctly? Okay, so tell us who you are calling and I'll.
Which one's the shorter of the two? Hold on, Your Honor.
Trying to figure out which one's the 50-minute one, Judge.
Well, that's okay. I'm just trying to figure out the lights.
Blue Cowboys.
How much? Okay, then we will be calling Dr. Behar Posey as our next witness by video.
Yes, you may. Just make sure that.
All right, here begins the video deposition.
Would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give in this cause?
All right, I'm going to pause real quick and I'm going to do this because I have been scrolling through and I see there's a lot of questions and comments that I want to get to. Okay, so that last witness had a lot of people having opinions, so I'm sorry. I know I need to get through the rest of this, and I'm going to. Crap. Here's what I'm going to do. Here's what I'm going to do. And it's because I'm sick. And I don't want to give this last witness the short end of the stick because this last witness I think is good for the hospital and it's important that we hear it because there's a lot of the ketamine stuff in there. I am going to get to all of the questions that I can this evening right now. There are 56 starred questions and chats that I have to get to. We're going on 3 hours. It's 11:17. I'm sick. I need to get to bed. I'm going to go through these And I'm going to begin tomorrow's live stream with this witness. I will begin the live stream with this witness. I will be fair. And honestly, it's probably best because I'm not going to be spicy, or we'll be able to talk about this in context. I don't want to give this witness a short or abbreviated analysis. I don't. And I fear that that's what I'm going to do right now. If I go through and play her right now, I'm going to be tired and sick, and I'm going to run short, and I'm not going to give you the answers that you deserve. So I'm going to be back tomorrow, and I'm going to play her in the morning, or not in the morning, first thing tomorrow night stream. Okay. So let's go to questions real quick. Now that we have that out of the way, that's going to make me feel better about getting these questions and not having to rush. Okay. Melanie Hideki, is this a case you would have taken or been willing to work on? I don't do personal injury. The area of law and the complexity of this law is so significant. Working on it, giving commentary or analysis or my thoughts, yes, I would have. I would have very, very, very likely given those thoughts to both parties, plaintiff and defendant, on what I thought was proper or not proper. Christy B, I've been excited for this recap all day. I watched the trial, then your recaps to validate my opinions or to get my questions answered. You're awesome. Thank you, Christy B. Summer Golden, hey, Rob, thank you so much for covering this case and being such a kind person. Does DFPS have immunity to anything they may have done wrong in this case? Also, did they have court today? They had court today. We covered that at the beginning. There was additional argument on the directed verdicts. We covered that at the beginning of the stream. And there was talk about jury instructions, but there was no jury present today. Is DCF immune? DCF is statutorily immune. They are protected by the legislature. If you want to change that, you have to talk to your legislators. Red Tail, Judge Carroll worked under Pat Corrales from 2008 to 2015 when he was appointed as a circuit court judge. Not a conflict of interest, but hard not to be swayed. He rules against her a lot. If you're thinking that he's swayed by her, he rules against her a whole lot. Laura Mott, is it safe to assume that Maya would appreciate that swoop? I think she would. I hope she would. Thank you for being you. Also, Rob, also a little spoon of honey, help coat the throat when it gets scratchy. Much love. Thank you, Laura. I need to take meds and go to bed. LK Ryden, regarding PTSD, have they done brain scans? No, they have not. PTSD physically changes the brain. We don't have that evidence. Matt Bond, g'day, my spiffy, legal, mumbo jumbo, talkie brother from another mother. How goes it? It goes, Matt. We're doing well. It's another day, my friend. Another day. It's another day. Casey Lewis, how difficult will it be for Jack and Kyle to not seem callous without being able to discuss their pain? It's not, I mean, they've already discussed their pain. It's that the judge will give an instruction that certain counts have been removed. That will be the remedy there. JM, why is Shapiro in the cheap seats and the dude with glass up front? I think there was sickness. I think Shapiro's not feeling well. I think that's why he's in the back. Lori Ross, please explain how a witness can get caught in so many lies or misrepresentations. So glad the jury asked the questions they do. Witnesses are people. They can get confused. They can get conflicted. Rebecca, we are back to your very generous super chat and question. Rob, lawyer, follower. However, he can't speak to a lot of this. I watch your recaps. Thank you for that. I have questions that Peter can't answer. Why is it that mom unaliving herself is the hospital's problem? That is a her thing, right? Yes, I'm an RN. So here's the thing. There is a concept in the law that has been more recently adopted in criminal matters, where you have the concept of cyberbullying in the context of criminal law, where we are now prosecuting individuals that are responsible for creating in the mind of someone who is a vulnerable person an irresistible impulse where they no longer have control over their brain in that moment or their thought process in that moment, and they do something entirely irrational, like taking their own life. So the criminal code has recognized that there is a ability to prosecute these people for that type of behavior when those actions are so significant that they cause such torment mentally to basically take the will You take the intention out of the act of suicide. You take that person's desire and will out of the equation because you have taken that from them by these acts. That's the argument that's being used here. The argument is the course of conduct the hospital engaged in was so sufficiently egregious and pointed in the direction of Maya and or Beata that it created in Beata's mind an irresistible impulse that she could not ignore. The irresistible impulse led her to taking her own life. And the standard that we have is that it has to be a substantial contributing factor to that irresistible impulse, and that's what attaches liability. That's why we're here. That's my best articulation of legal standard. So I hope that answers your question. Mary Coppola, and what if they don't speak English? That creates a problem. They can then seek out anyone who's a third party who can observe and be trained, who speaks that language. Morgan Abate. If that is Laporte, she's so quick spoken, stressed, and is not just redirecting Beata, but is telling Maya what she can say too. Listen to her speed and tone. I'm going to go back and listen again. Melinda McKay, I have Marfan syndrome, a genetic connective tissue disorder. First hospital misdiagnosed me and sent me home. Next day, ER surgery, nearly died. It really sucks when professionals don't do the work. It's this case. I have been amazed and astounded by the people that have shown up to watch these recaps, and I have learned so very much from all of you about the experiences that you have gone through and how this case in particular speaks to concerns that you have on both sides of the aisle, both sides. And I think that we need to address how proper treatment can be altered, how we can fix some of the systems here. So the BD, GAL, and her had to be on the calls. Why? The judge ordered it. This was a shelter order in place. So the shelter order was in place, and the judge said these calls have to be supervised. JM, wasn't there a big deal about whether BD was authorized by DCF for the calls or something? No one asked her about that. That's correct. There is. And we have a back and forth with the GAL, and we're going to get instruction from the judge on what the orders say. Della Sander, by the way, please recognize those who have donated less because they have less. I love all of you and all that you guys bring to the chat and the discussion and the back and forth. I try to pull up chats that are not super chats. I try to pull up chats and engagement when I can see it. The fact of the matter is that there were 5,000, almost 6,000 people watching tonight. And when there's that many people engaged in the chat, it's physically impossible for me to see all of it. I try my very best. I promise you, I try my best. And I don't discredit anything. I mean, the mere act of subscribing to the channel is not even subscribing, just watching, man. It means the world to me. So I really do appreciate each and every one of you. And I don't mean to cut any of you short. I try to push these streams long, and I try to get to all the questions. I push against my own capabilities all the time when I do this. Della, thank you for the contributions and for your engagement in the chat and for continuing to watch and contribute and engage verbally in the chat. Thank you. Beck's Fire, I think that BD interrupted the prayer and these recordings are Laporte. It's easy to understand why Maya would recall that all the interruptions were BD. I can see that too. Thank you. Lori, can they ask you to read the transcript from the phone calls of disputed voice? Nope. Argumentative. Rebecca, Rob, one of your mods shut me down. Not you. That, again, also is the speed of the chat. When I said that all members have no restriction on speed and timeouts and like how quickly they can chat, I personally have wrongfully timed people out before or shut them down. Chat's moving really fast. I ask for a little bit of grace and a little bit of patience while your guys are chatting about this subject. Thank you, Rebecca. You've been great tonight. Charlotte, when I've been a juror, I thought having the witness look at us seemed staged. Only cops did it. She's looking at the person she's talking to. With regard to Miss Laporte, she wasn't, because the question was being asked by the judge, and then she looked down, sent her into her lap. So she wasn't looking to anybody. She looked in her lap. Can't really be this old. Rob, with all the testimony over whose voice is on the phone call, why didn't one side or the other have a voice print done? Your thoughts? I think it's not. I think that wouldn't survive a Daubert hearing. I don't think that's a valid expertise. I don't think you could do a voice match and have that expertise via phone call and those short snippets reliably in print. That's my opinion. Plus, those experts probably really expensive. Courtney Meek, are we going to talk about Shapiro's wife and her Facebook shenanigans? Courtney, I'm going to have to take a look at your DM. I will pull that up tomorrow. I did see that you sent a chat later that said that you sent me all you had. I will pull that up. I promise you. Jolyn Elliott, can you make sure to play her exit? Everyone say it's juicy. I try to get as much as I could. Rebecca, again, I know touchy subject, but what Maya has gone through, had the bad thing never happened, i.e. what the prosecution states the issue was. Oh, you mean had the self-inflicted harm never happened by Piata? This case is tough all around. I don't know that there's a right opinion on it. Marley R, did Spidey ever get back to you? Yes, he did. He's happy to give input. I want Sally Smith on the stand first. Blessed in Texas. Why did Niehus get to read directly from her typed notes? She shouldn't have. That should have been prevented, and the judge kind of cut her off. Just a red girl. The reason it bothered you is the contempt she has for the child. I didn't say it out loud, but yeah. If she has special needs child and she works hard and is burnt, she did not like Maya. She felt she was a spoiled child without a real issue. Who got a Netflix documentary? That was the last little part that I read into that got a Netflix documentary. Yeah. Ghost Biscuit, I think it would save everyone time if the plaintiffs first. Are you familiar with CRPS? That was a question that should have been that was a miss. OB nurse, are you going to go to the ED doc and TGH? I'm going to do that tomorrow first thing. And I saw that chat, and that's why I'm doing it first thing tomorrow. AG, she rolled her eyes at him and has been glowering through the cross. How do you think that might affect the jury? You guys heard. Fairy Godmother is member of the AMBU squad. I know there is a big difference between EMT1 and paramedic. What she said was comparative to a paramedic that was untrue. And for me, everything after that was suspect. Interesting. I didn't pick up on that. Courtney Meek, I said what I have. I'll keep digging. Thank you, Courtney. That's awesome. I'll cover that tomorrow. AG, her hostile testimony gives me doubts as to her capacity for empathy and pain perception. She refers to Maya as the girl and the child callous. Those references are less callous than some of the other remarks, but I can see where you're coming from. I mean, who gets to choose which jurors are alternate? Every case is different. Every judge is different. It's usually random. Could the juror questions affect those? Which ones get to choose and deliberate? No. Baby Gator, I can't tell you how many times I've said I was in pain without displaying signs. I was in pain because the minute you start showing that emotion, it's hard to stop. A lot of people have echoed that, Baby Gator. Thank you. Automata, her fighting Anderson is a positive. If she didn't, it would change how motivated she was. It just wouldn't put it on full display for the jury. It was on display. Marsha Barnick, why aren't her letters private? It reminds me of her prisoner's treatment. Supervised visits. At this point in time, the shelter order had been entered. The court had sufficient probable cause to realize that, or to believe that there might be a risk of harm. So the shelter order controls what this child is or is not to do. This is the court taking custody of the child. The court has taken custody. This is, in fact, a person who is under court supervision. So the court, by its agents, gets to supervise the letters. Melanie, what did Jules notice with the jury on Niehus witnesses? Oh, God. Jules has been giving her comments left, right, and center on that. I would defer to her. Julie Jam, the defense had this lady wear pink to soften her. It didn't work. She went into the sessions with the mindset that Maya was faking it. It's possible. Rebecca, doth protest too much, as the Cowboys. No, they are terrible. Susan, she's not a nurse and probably hasn't been taught to truly assess pain, and that pain is what the patient states it is. Basically, how a lay person would assess pain. Susan, I'm not discounting this. I saw your other comments too. I agree with you. She was not asked to give an assessment on whether the person is or is not in pain. That was not her job responsibility. But the unfortunate thing is that is what defense counsel asked her to present to the jury. The defense attorney put her forward as having an expertise or experience that she didn't have. And that led to that cross. That's why that was so brutal. Ghost Biscuit, why is it always the mom? Jack was the parent that was home with the kids. Not that I think either of them did anything except try to get help for their daughter, but it's always the mother. Not always, but I see your point. I've seen enough cases to know that dads do that too. There was commentary about maternal instinct, and I do believe that there is such a thing as maternal instinct. I do. Casey Cat and thus what me, Matt Bond, Skoda, Billy and Ange, and so many others in the chat have dealt with over and over with healthcare professionals in the world when it comes to our RSD and CRPS. Exactly this. A misunderstanding of what it is. What it is. Susan, CNAs are task-oriented. They complete tasks. They don't interpret or assess. Why is he asking her questions that are out of scope of her knowledge? Because that was what she was asked to testify to. That was what she was asked to testify to by the defense counsel. By defense counsel. They put it at issue. They opened that door for him to just drive a tractor through it. They did. Angie, studying and working in healthcare, I had it drilled into me that when it comes to pain, it's up to the patient to determine if they're in pain or not the providers and caretakers. Different opinions are in the chat. Mimsy, thank you for covering this. I'm so glad I found LawTube and so found so many compassionate and willing lawyers to share their knowledge on the law. Thank you, Mimsy. That means a whole lot. LK Ryden, I wonder if he keeps going because he can tell that the jury wants him to, like the Jody Arias case, which brings in its own issues. He didn't overstep. The judge kept him in line. Nikki Lewis, oh, I forgot this witness. I bet the fourth swings scale. In my opinion, the fourth is the ER. We're getting that first thing tomorrow. But the third does two for me. Yes, jury be tough to swing now. Jury will be tough to swing now. Interesting case. It is. Christina Marie found part of CB's depot where she says she was call monitoring and not DCF. Fox 9 Minneapolis, St. Paul video, Kathy BD depot, 51 minutes. I'm not going to pull that up right now. I'm going to write it down. And I might mention it tomorrow. Fox 9, Kathy BD depot, 51 min. Christina, thank you for that. I'm going to pull that up at some point in time this evening. Jonathan Duger, feel like fMRI is the only way to prove pain. I'm unfamiliar with the process. Laura Leanne, chronic pain equals they accused me of drug seeking when my appendix burst in the ER. I've heard of that story actually before from two people separately. So that is concerning. Many hugs to all on chronic pain survivors in the chat. Get better, Rob. I will try. Laura Biddle, next time witness is credible, except she saw Maya and Beata before they went to J Hatch. Why did she not report them? Think about that. Interesting question. The only Latina, Anderson destroyed her. That cross was brutal. LJ Peach, her whole demeanor was bad and combative. The cross was brutal. Southern Mom, what kind of level witness preparation is acceptable? You prepare them. But you don't go over their testimony. You go through what you anticipate walking them through and what cross is going to be. You can go through their whole testimony. There's nothing wrong with that. It's probably what was done here. I usually prep the hell out of my witnesses to prep them on cross. If I think a witness is going to get combative, I bring in my partner and I have them beat the hell out of them on the stand, not physically, verbally, to show them what it's like. I do. That's appropriate. That's allowed. It's fair game. I think that that should have been done here. Amanda, thank you for the super chat. Amanda, again, the witness is so hostile that with Anderson, even towards the judge at times, can a witness be dismissed for being hostile and rude? No. They can be admonished and instructed. They can even be put in contempt, held in contempt, but not dismissed. Lindsay, how weird is it that approximately a year and a half ago, you had never even considered coming on YouTube, and now we're here? Really weird. Really weird. Really weird. But I wouldn't have it any other way. I can chat with all you fine folks. Rebecca, you have strep, my dear. Go get tested. Oh, I hope I don't. I'm going to go figure something out. Will you be following the Dr. Deborah Jensen saga in Lehigh Valley, Pennsylvania? Over 70 families accused of MVP by her in one hospital system. The Sharpie, if it goes to trial, I will try with this experience on this case. I will try. If you can send me the details either in Twitter DM, Lumber Law, or at lawandlumber@gmail.com, that would be much appreciated. Lynn, 2574, many of us already know how harmful the war on opioids was to chronic pain patients. Now the world is getting a glimpse of the medical discrimination we face just to get care. Chronic pain is an area that I had never, ever, I had known of its existence. I had focused on it. I had never had the opportunity to learn as much as I have in covering this trial. Ever. I have been amazed and blown away by what I've heard during the trial coverage, but mostly by what I've seen in the chat. It's what I've seen from all of you. That has been the most impactful thing about covering this trial so far. So this trial has taught me more than I can ever teach you about the law. And that's really cool to realize and experience. For those of you that are still watching, thank you guys for being here. If you like the content, please consider subscribing. You can hear the voices going. We have 875 subs right now. If you guys subscribe, I'd like to get to 200 by the end of this trial. It'd be fun. Get a little celebration going. I don't know what we do, but we can celebrate. So to those of you guys that are watching, I've made a promise at the beginning of the stream. I didn't forget. I did not forget that promise. Before I do that, I want to say to the mods, the people that have been tuning in, thank you to the mods. Thank you to the mods, both YouTube, Discord, everybody. Thank you to the mods for allowing this chat to function, for putting in the time, for doing all that they're doing. You guys are amazing. You're incredible. I can never thank you enough. For the people in the chat, thank you for everything. For everything. Debbie Joe, he breaks a bed and inadvertently makes a community. You guys made the community. I just did a video. That's it. The Roe Bear Network. Why go to ER for a chronic issue? Because you have an acute pain. That was what was discussed here. You guys, I'm going to rest up and feel better. Before I do, I made you a promise. Okay? Here's the outro. I hope you enjoy. Love you all. Enjoy something I get to make, or I made. And I'll catch you guys tomorrow night.